Page-wise adjournments. List 1, page number 6. Page number 6, serial number 10 to 12. Page 7, 13, 14. List
My
number
lords,
2,
my lords,
page number 7.
serial number 14. List 1, serial number 14. Appearing for the appellant, there was two cases connected with 8762 and 63. Only 63 is listed today, and 62 was kept below. So kindly give us a adjournment date.
List number 2, page number 7, serial number 14. Page number 8, serial number 15. Page number 9, serial number 16 to 17. Page number 10, serial number 18 to 21.
Serial number 19, madam. Here for the respondent, you have informed the other side also.
And for the petitioner.
That's after 2 weeks, madam. And the settlement is going on, madam. The parties. We'll answer the list is next week so that we will read. No problem. Interim order में कल.
1-4. Page number 11, serial number 22 to 31. Page number 12. Why use my? You're for the respondent, no?
Respond.
You have to come this side.
Appear for respondent, my lord. My serial goes outstation. Please next Tuesday.
Tuesday. 1-4.
Obliges.
Serial number 30, my lord. Serial number 30. We are for the respondent.
Serial number?
From Italy, 1 week time ಆಗೋಗಿದೆ.
We have to file the objections, my lord.
Objection.
One short date.
3 weeks ಆಗಿದೆ ಸ್ವಾಮಿ. Kindly ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
My lord. Yes, my lord. My lord, the appearance for the counsel advocate, he is not well, my lord. So I'm proxy advocate. One short date may be given. He is an out of station.
1-4.
Most obliged.
Page number 12. Serial number
Kindly
32.
share the granted ಸ್ವಾಮಿ. Already evidence observed evidence ಸ್ವಾಮಿ. Go ahead.
My lords, serial number 32, my lords.
32 to 39.
My lords, I have informed the other side, my lords. My lords, some inconvenience, my lords. My lords, my lords, 1 week, my lords. My lords, I'm for the respondent, my lords. Kindly, my lords.
Legal issues which are involved, where the seniors have to come on to all simple matters. And this court grants stay, and we can't, it's the responsibility of the court to see that it is disposed of at an earlier stage.
My lords.
This is matter on Tuesday, this also on Tuesday.
Obliged, my lords.
Yes.
For list number 1, parted matter, serial number 1. Chintan Chinnappa for applicant.
My lord, on submission.
Corresponding.
List number 3, my lord. Serial number 1, 23 and 26, my lord. Senior is not feeling well, my lord. Serial number 1, my lord. These three. And 23 and 26, my lord. Senior is not feeling well. He's suffering from throat infection, my lord. So kindly have it on next week, my lord.
Inform the other side.
Yes, my lord. I have informed now.
1,
23 and
13 matter.
26, my lord.
13 matter. Even if the senior is not there, you see here, you can dispose of those matters.
Next week, my lord. I will ask.
7-4.
Much obliged.
List 1, packet matter, sale number 1. Chintan Chinnappa.
For third respondent.
My lords, I appear for the applicant. Might the matter be posted on another date? Senior counsel is unable to render his presence today, so a short adjournment.
I appear for the official liquidator, my lord. May I request for any Thursday to be fixed, my lord?
Any?
Thursday, my lord. 3rd or 17th, my lord.
Anytime this Thursday business will not do. This is not the company court.
Your lordship's mic is off, my lord.
This is matter on 9.
Much obliged, my lords.
Sale number 2.
Petition. Transfer petition minutes from Bangalore to Kanakpura minutes. Section 9 and 125
Who
petition
appears
is
for the
pending.
respondent?
That is Renuka Devi.
Heard the land counsel for the petitioner in part. No representation for the respondent. This is matter as quarter tomorrow.
Please.
Sale number 3.
So the respondent in this case, my lord, petition this case, my lord,
Authorized.
wife petition, my lord, seeking for transfer. Last again, they are arguing the matter, my lord. My side, they are arguing the pending, my lord.
Huh?
Sir, transfer petition, my lord. I have no objection to transfer the Kadur, my lord. But one thing, my lord, kindly permitted to appear through VC, my lord. Respond.
That you can ask the court
Please, allow.
wherever it is required. All the time it is not possible to appear through VC. You can request the court. I will give you that liberty, but all the for
Liberty
all
may
the
be given.
examination and all, every time your presence for the evidence you have to be there, not
Please.
through VC.
Please.
The present petition is filed. Petition is filed seeking transfer of MC number 90 of 2024, pending on the file of the Senior Civil Judge JMFC Kadur to the Court of Principal Senior Civil Judge and CJM Chitradurg. When counsel appearing for the respondent submits that he has no objection to transfer the matter, however, he may be permitted to appear through VC. The request of the petitioner, as far as appearing through VC is concerned, for the examination of at the time of trial, for the purpose of examination, there cannot be, he cannot appear through VC, and he has to be present before the court personally. For other occasions, the petitioner is at liberty to to request the court. He is at liberty to make an appropriate application, and the trial court may consider the same in accordance with. Yes, accordingly, the so and so is allowed, withdrawn and transferred, and the wife shall cooperate with the. Yes, next.
Sale number 4. Renuka HR for appellant. Vinod Reddy for respondent.
Password.
Sale number 5. Vasudev Murthy BK for appellant. Yes, Nagesh.
You appear for the appellant.
I appear for appellate.
Where is the counsel for the respondent?
CH Reader.
Last time also, so many times he has not appeared.
Let's see. Is it in part? When this has come up before me? No endorsement.
Who has the bid? He was not there. Even on the day, he was not there. We'll pass over and pass orders in the afternoon.
I will not be. This
Tomorrow.
is 11,
Huh?
11 years old boy.
That's what we'll
We'll argue the matter and
no, we can't have it in piecemeal. Either in the afternoon or tomorrow, whenever it is convenient to you.
Monday it can be done.
Yes, Monday is a holiday, Tuesday.
Tuesday.
Yes.
Cell number 6. Cell number 6. Syed Abdul Sabur.
Notice to be ordered, my lord, because respondent has not been served copy. This has not been ordered.
2018, the appeal is not, no notice is ordered. Which are who are the respondents?
KSRTC.
Who is the counsel for KSRTC?
FS Dabali is there and again authorized.
Mr. Dabali appears.
Yes, okay. On behalf of KSRTC,
For the respondent, Mr. FS Dabali
yes,
is directed to take notice on behalf of the respondent, and the learned counsel for the petitioner appellant shall serve the copy of the appeal memo on the counsel. List this matter on 22nd of April. Delete from the caption for dismissal.
Serial number 7 for orders matter. Satisha T for appellant.
For respondent.
Purti Hegde, Nagaraj.
Second respondent.
Satisha.
Password.
Yes, ma'am.
Well, I should have to file the translated copies.
Judgment is in English.
Yes, ma'am.
If it is English, remaining documents not necessary.
Yes.
Password.
Yes. Serial number 8. Suguna Reddy for appellant. Or Srinivas Gowda.
No representation for the petitioner. The list is appellant. This is matter for dismissal. Give a date next week. Not next week, thereafter. 16, 17.
16.
Yes. 9.
Serial number 9. Nagaraja K.
9, my lord, I appear for the appellant. There is some, my lord, disturbance as far as video is concerned. May be taken up on some other. I am ready from my side, but I can't see the court.
9th. This is matter on 17th.
17. 4. Number 10.
For
For
respondent.
admission matter, serial number 10. K. Ravi Shankar.
For respondent number 3, Milord, it is only for quantum of compensation.
They will pass over this and pass orders, whether he is there or not in the afternoon. Pass over.
Serial number 11. Pradeep B for appellant. SV Prakash.
Where are the insurance company counsel? Where is Mr. Pradeep? Nobody appears. Pass over.
My lord, instead of tomorrow, my lord.
Why?
My lord, today afternoon, my lord, I have
Can you
so.
send your colleague? Will take care of your interest.
Please, my lord.
Serial number 12. Shripad V Shastri for appellant. B Pradeep. 12.
No representation for the appellant. Dismissal. Give a date on that week.
16. 4.
Yes. 13.
Serial number 13. Serial number 13. Naveed Ahmed.
Same order.
4. Serial number 14 adjourned. List number 2. Serial number 1. List number 2. Serial number 1. K. Prasanna Shetty for petitioner.
For the appellant, my lords, in this matter, already 3 times notice has been served, my lords. Even we have served notice to trial court advocate, my lords. It has been stated as not claimed, my lords. It is a humble request to make it as held sufficient and dispose the matter.
Not claimed the third time. The notice to respondent returned with an, as per the posture returned as unclaimed amounts to deemed service of notice. Yes. What is the matter about?
My lords, transfer from Bangalore.
It's already name is set. Yes.
Bangalore to Kundapura, my lords.
Bangalore to
Kundapura.
the distance?
Distance is 440 kilometers, my lord. 40 kilometers. 440 kilometers.
440 kilometers.
Yes, ma'am. Husband has filed a divorce petition, my lords, in Bangalore itself. Husband filed a divorce petition in Bangalore. Wife resides in Kundapura, my lords. After separation, wife has
The present petition is filed seeking transfer of MC number 1533 of 2021. Pending on the file of the 5th Judicial Principal Judge Family Court to the Court of Senior Civil Judge Kundapura. The facts of the case are the marriage has taken place on 28/7/2009. At
Bangalore.
Before the office of the sub-registrar Banswari and Bangalore. In the wedlock, they blessed with a male child on 29/3/2009. The disputes arose between the parties, and she filed a complaint against the petitioners filed a complaint against the respondent on 29/2/2020 under section 498, 323, 324, 504, 506, section 34 of the IPC, which is registered as crime number 49 of 2020. And she has also filed a petition under section 125(1) of the CRPC, that's criminal miscellaneous number 15 of 2021, before the principal civil judge JMFC Kundapura seeking maintenance. On 9/3/2021, husband has filed a petition seeking divorce on the file of the principal judge family court at Bangalore. It is submitted that after disputes between the parties, the wife is the petitioner is staying with her parents at Kundapura, which is about 450 kilometers from Bangalore, and it's difficult for her to travel all the way from Kundapura to Bangalore on each date of hearing. This court has held the notice to respondent sufficient as as per the postal shira, the notice returned as unclaimed. Next file. Having heard the counsel for the petition for the material on the record, considering the fact that already the criminal case and also criminal miscellaneous are pending on the file of the considering the fact that already criminal miscellaneous is pending on the file of the principal civil judge in JMFC Kundapura, and considering the distance of 440 kilometers, this court is deemed it appropriate to allow this petition accordingly. So and so is withdrawn, and so and so is transferred to so and so, and the wife shall cooperate with the.
Please.
Cell number 2, Bhargav G for petitioner, Vinay SN.
Lordship.
I am for remand, my lord.
Yes.
This petition is to transfer an MC case from Kunigal to Bangalore, Your Lordship.
Kunigal to Bangalore.
To
What is
Bangalore.
the distance?
Please, my lord.
Distance is Bangalore.
Huh?
The petitioner's residence is in Bangalore. The wife is staying in the Bangalore with a child of.
What I'm saying, Kunigal to Bangalore, what is the distance?
Distance is 75 kilometers around. And it takes approximately 2 hours to travel from here.
Children are there in the front.
Yes. A girl child is with the petitioner, Your Lordship.
Age?
Age is 7 years now.
Huh?
7 years now.
Yes.
Please, my lord. The petitioner admittedly residing in Dasarali.
Residing in?
Dasarali, Tumkur, Bangalore.
Hmm.
So the Kunigal court is journey is only 1 hour. So compared to come to the family court and dispose of the matter at Kunigal court itself is very convenient to the respondent and petitioner also. Admittedly, the respondent is an agriculturist. Even as per the pleadings of the petitioner alone, he has got a wetland, dryland, and garden land, farmhouse. He himself and his mother staying at village. It is far away from Kunigal, about 30 kilometers. He has to attend the court at Kunigal. Now,
You will travel 30 kilometers whenever you have to
But-
attend the court.
even pendency, madam, pendency. Regarding pendency, MC, your family court is more compared to the Kunigal court. It is very far, even this one.
Okay, you're traveling 30 kilometers to attend that court. So instead of that bus or train, you will take another train to come to Bangalore.
Madam, time frame, madam. Even now the case is set down for.
The MC,
Also,
it is set out for,
evidence of the petitioner in MC case.
which is,
It
when is
it
the
is
MC
filed for
filed?
restitution of conjugal right.
2022, your lordships.
Huh?
2022 is MC filed, and one submission, your lordships.
They are ex parte. They are not appeared before the civil judge at Kunigal.
MC is of the year 2022, CP is of the year 2023. When is stay granted?
Stay is not granted yet.
But then,
Here, stay is not granted, madam.
then how can we transfer it now? After the trial has commenced?
Now, as per the order sheet of the,
Submission, your lordships. She is staying with the child is not well and it is little bit
No,
quite
that's all
abnormal,
correct.
your lordships.
All those facts are there. What are you doing?
And-
Filing the CP in the year 2023 without even having a stay. And now 2 years have passed by.
Is your lordships, before filing of the written statement, like we had approached this honorable court to
What are you doing?
grant stay,
Approaching is not
but
sufficient.
the matter did not reach your lordship.
So many
That is the
matters are
reason.
reaching and so many matters stays are there. You can't say that matter is not reaching.
Your lordships, one submission and even
Once the trial commences, when the court has spent considerable time on the case, this is not the stage to
child
transfer
is
the
unwell,
case.
she will have to look after the child, your lordships, and even in the partition
And
deed
what
of the
is-
respondents,
How are you prosecuting this
every
matter?
deeds and every cause title shows that they are residing in Bangalore, your lordships.
Who?
The respondent, husband.
no,
Where do you see
Your
that?
lordships may kindly see annexure L, page 83. It is a partition deed among the family members of the respondent, and the schedule, your lordships may kindly see 85, your lordships, including his Aadhaar number. Girish, ಇದೇ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇನೆ. That means once.
my lord, I am not disputing that.
Including his Aadhaar card, including their schedule, everything shows that they are residing here. Simply to harass the petitioner, they have filed the
What you're
MC
not
petition in
denying
Kunigal.
that you're staying in Bangalore.
Yes, no, madam. Till my death of my father, I am staying here. My father look after all the agricultural land. Even as per the partition deed, I acquired landed property. Myself and no mother, both are staying in the village. There is nobody look after the land. If I am left the village, I am maintaining sheep shed, I am maintaining cow shed, including coconuts, araka, everything is there.
They have siblings.
If I am not stay there in the village, what the fate of the agricultural land? Your Honor, my lord, you are very well aware. No coolie person is available, no labor is available in a village. I have to maintain
Your lordship.
tractor and trailer and also all agricultural
Understood,
implements.
yes.
Your lordships may kindly see the school certificate of the daughter. She is unwell. Nobody is there to look after her. And even nothing is paid to the petitioner. Nothing is there. She is not even working woman. And this is not possible, your lordships, to attend the...
My lord, they have made some allegation. If we granted 3 days time, I would file the necessary objection and argue the matter. I don't ask any time. Please grant 3 days time only.
You file your wakalat.
Day by day, before study. Only day after day, I filed the power. I am not filing the objection. I want, even yesterday also, my colleague
To serve
short
the
time.
copy,
Only 3 days.
try to serve the copy to the trial court
Even stay
advocate as
application
well.
is, copy is not served to me.
Your lordships.
Finally, a week's time is granted for filing objections. Let's give a date.
8/4.
Much
Okay.
obliged to your lordship.
Much obliged, my lord.
Yes, next.
Serial number 3, Nayak NR for petitioner. Serial number 3.
This matter came upon on 21/3/2025. There was no representation on behalf of the petitioner, and the matter was directed to be registered on 22/3/2025. Even on that day also, there is no representation. Where is that? Sure. A memo is filed stating that MC number 2405/2024 was disposed of by way of a settlement. Hence, nothing suffices for consideration in this petition. Accordingly, memo is taken on record and the CP is dismissed as withdrawn. Yes, next.
Serial number 4. Serial number 4. Namita Mahesh BG for petitioner. Bimbadar.
On 26/3/2025, there is no representation on behalf of the parties. Directed the matter to be listed under the caption for dismissal today. Today also there is no representation on behalf of the petitioner. Accordingly, the petition is dismissed for non-prosecution. Yes.
Serial number 5.
Not so I appear for the appellant.
For
in
the
this
first
matter.
respondent.
Code B
Not
for
sir.
appellant.
I have filed application on Lord 5th March 2025. Lord, to declare Lord respondent number 6 and 7 became measures and Lord the discharge the Lord the guardian.
What is this await service of notice in respect of R2 and R3?
Lord, so I have taken steps, Lord. Taken steps, Lord. The deficit port fee was there. My process.
Non-compliance of office objections on memo for treating R6 as LRs of
Lord,
deceased.
I have filed, Lord. That is on 5th March 2025. I have made an application to
No,
discharge.
you have filed. There are certain objections which you have to. Non-compliance of office objections raised on memo for treating
Lord, that
R6.
memo, that initially, my lords, I had filed a memo to my lord the this.
You have filed an application now.
Now I have filed an application.
So that the you are not pressing on the memo.
That no, my lord.
But the land counsel for the petitioner submits that he is not pressing on the memo filed for treating R6 as LR of the deceased.
R6 and R7.
R7. Then what is this non-compliance of objections raised on IA 1 of 19
Copy not served.
Copy, my lord, I have served.
for appointing R6 as the guardian of R7?
Trial court advocate serve ಮಾಡಿದ್ದೀನಿ.
Have you
ನನಗೆ
served the
serve
copy
ಮಾಡಿದ್ದೀನಿ.
on the other side?
No, no, no.
Yes, ma'am. This
The
not-
copy was served before the trial court advocate, not to me.
Read to him. Please this matter on Wednesday.
Lord, that application, Lord, sir, declaring Lord the
Let him
R6
look at it. Let him look at it. Is this matter on Wednesday? Delete from the caption for dismissal.
Serial number 6. VP Sidramaya for petitioner.
What is this R2?
It's a review petition, my lord. There is a delay in 3,449 days delay, my lord. There is a delay in 3,449 days delay.
Is that what is that? What is this?
It's a MFA, my lord. MFA was dismissed, my lord. We have not contested that case, my lord. In earlier case, my lord, MFA, we have not contested that case, my lord. It was dismissed. My lord, earlier advocate was expelled, my lord. We don't know that advocate was expelled.
When was the disposal of the MFA?
Only pass over, my lord.
What serves in this? Yes.
The orders matter, serial number 7.
The petition in this case.
Yes, Venkat Subbarao.
And the victim became takes fresh steps. I served the trial court advocate and filed appointment also, but he not appear, advocate.
You have served?
Where
is the memo?
15/7/2024, I filed memo, my lord.
As per the order passed by this court, the petitioner has served the handsome counsel appearing for the respondent before the trial court and filed a memo to that effect. What is the name?
Such,
you should file the memo. You have to tell when, where, how, who. That's what the memo should contain.
Badri advocate, in trial court, page number 9 in petition.
What is the name?
Badri advocate, madam.
It looks like SC Birender.
Please, madam. Please, madam.
You said Badri.
No,
when the court is Birender, you say yes. No. When you're filing a memo, here it should contain that as per the orders of the court on so and so day, I have served on so and so. The advocate's name is so and so. Not like this. The petitioner shall file a fresh memo before the court, furnishing all the details. And the registry is directed not to accept any of the memo wherever hand summons are served without furnishing the details on whom, on the advocate, the name of the advocate and other details.
Serial number 8.
2 weeks, madam.
Kirti Prasad,
Yes.
2 weeks time, madam.
8. Kirti
Why
Prasad.
2 weeks?
File it, madam. File it, register and put up. Week time, madam. File it.
For what?
File memo, madam. Fresh.
1 week. A week's time. Yes, 8.
Serial number 8. Kirti Prasad. First time.
If it is unclaimed, why again second time? No representation for the petitioner. This is matter for dismissal tomorrow.
Serial number 9. Sunita H. Singh for petitioner.
Same order.
Serial number 10.
My lord, this is a transfer.
Yes, my lords, for the respondent. My lords, we got the wakalat. We'll file it today along with the objections. A week's time may be granted.
Yes, a week's time. It is submitted that so and so has instructions. Give the name. So and so has instructions to file wakalat, and for filing objections, a week's time. List this matter on 15th of April.
May I request before 15th April, because trial court also is hearing on 15th April, my lords. 15th April.
Yes. 15th.
15th April.
Yes, next.
Serial number 11.
Lordship, in this case for appellant, my lordship. As per the order dated, my lordship, 27/2/2025, the Honorable Court directed the appellant to serve the copy of the trial court parties, my lordship. That regard, my lordship, I served the parties respondent number 7 to 9, my lordship. I filed the acknowledgement in the counter yesterday, my lordship.
No.
My lord, on last occasion,
One
this
minute.
court,
Is it serial number 11?
please,
Non-taking of steps for substituted service of notice. What is that?
kindly see the last order dated 27/2/2025.
20?
27/2/2025.
Twenty-seven two says, Sri so-and-so appears through video conference and seeks time to take steps for substituted service in respect of respondent number 7 and 9.
Copy was served to the parties before the
Asked you to do it.
learned counsel is on record. They,
It's not learned counsel on the record. Court should tell you.
Please.
You said you will file substituted service of notice
Lord,
and shall file before the order sheet of the trial court. What is the status of the case before the trial court? This
That is-
also I have asked. Do you have the status of that?
I have the online copy, my lord.
Give that.
It is civil for arguments, my lord. Final arguments.
Coming to a final argument.
Final argument.
That's why I said 2018 MSA,
There is
without any stay, it's pending here for service of notice on the respondents. And by the time something was to happen in the trial court, that's why I wanted the status. Now it is posted for final arguments. I do not want to interfere at this stage. Are you the advocate on record?
No, I'm not.
Ask him to come pass over.
Please, please. Please.
Serial number 12, C. Shankar Reddy. C. Shankar Reddy for appellant.
Yes.
S. Mrutyunjaya.
There is 109 days delays in filing appeal, my lord.
Yes, we'll condone the delay.
Yes, my lord.
I number 1 of 23 is filed to condone the delay of 109 days in filing the appeal. For the reasons stated, so and so is condoned. No objections are filed by the respondents. List this matter for admission
Serial number 13.
on 28th.
My lord, I'll file objections, my lord. Can you 2 days time? I'll file, my lord. 2 days time may be granted, my lord. Sorry, my lord.
What, even if you file also 109 days will be condoned, or else I'll not record that.
Yes.
The
Sorry, my lord.
IA is filed, say to condone the delay of 109 days in filing the appeal, considering the reasons stated. The delay is condoned. Yes, next.
Much
Serial
obliged.
number 13.
Lord, in this matter, week's time may be
Ramesh
granted,
K.
my lord. I will
Appellant.
take necessary steps in this matter in respect of respond number 3, 4, 10.
What is the
and-
correct address?
My lord, I will take instruction.
You
from-
have taken, you have taken out notice on the address
My lord,
as furnished
please.
in the, as per the.
Otherwise, my lord, one request, my lord.
Uh.
I will take instruction my counsel before the trial court. My lord, I will file the dispensation of respond number 2 to 10, 2 to 12, because my lord, they have the purchaser of the scheduled property. But the
So why
respondent
don't you serve notice on the counsel appearing before the trial court? Stay is granted in this.
stay is granted. Matter was already admitted, my lord. My lord, kindly have it next week, my lord. In the meanwhile, my lord, I will.
Finally, list next week
Oblige.
at the request of.
Date may be
counsel
given
for
in this matter, my lord.
the Appellant, give a date.
3, 4.
Oblige.
Next.
Serial number hearing on interlocutory application. Serial number 14, B.M. Alaswamy for appellant.
Look
Respond
at the
number,
respondent.
for respond number 1, my lord, pendency of the appeal, my lord, R1 has died.
No, that's what they have filed. Where is the counsel? No representation for dismissal tomorrow. Next.
Serial number 15.
Appearing for the appellant, my lord, in this matter, kindly pass it over.
Pass
My lord,
over.
appearing for the appellant in this matter.
Yes,
appellant-
pass over.
Serial number 16, Girish B. Baldare for
Yes, my
appellant.
lordship, connected matter are already remanded to the
Appearing for proposed respondent number 2.
beneficiary is not made as a party.
It's already impleted.
Is
The
already remit.
respondent is impleted.
Yes, my lordship. Not impleted. Not impleted. If application came to be filed, notice has been issued.
IA number 3 of 23 is filed to implead the beneficiary as respondent number 2. The notice is served and Mr. K.S. Bhimaya is appearing for the proposed respondent. Considering the fact that the beneficiary was not a party to the proceedings, the R2, the IA number 3 of 23 is allowed by pleading the beneficiary as the respondent number 2. Accordingly, the petition is allowed. Next, it is submitted that in respect of the very same acquisition,
Lordship judgment.
several appeals or several matters are remanded by setting aside the award passed by the reference court. Passed by the reference court accordingly in the light of the same. This court is passing the following order. Vindhya, you don't record all this, only this part. This the beneficiary herein shall be made as party before the reference court. All whatever the contents in the order. Yes. Where is that?
Delay.
Number 1 of 23 is filed to condone the delay of 909 days in filing the appeal. For the reason stated, the delay is condoned on the condition that they are not entitled for interest for the set period of 909 days. Yes.
Much obliged.
And the petition shall amend the appellate shall amend the cost title.
Cell number
Court fee
17.
is liable to be refunded.
Everything.
Cell number 17. Manoj Kumar.
The remand of the matter, since beneficiary is not made the party matter.
You filed the application now?
My lord, I have already filed, and IA number 2
is ordered.
Yes, ma'am. We have already served upon it, ma'am.
No, is it ordered? IA number.
Yes, ma'am.
IA
It
number.
was allowed, ma'am.
Where is plead petition?
To grant leave.
IA 2 is not
My
there
lord,
in
in
the
183.
3 of 1.
on amendment of cost title in respect of impleading R2 as per order dated 23/2025.
Please, my lord. I have the amendment petition is ready with my lord. I should do it
Tomorrow.
please, ma'am.
Cell number 18. 18. Vijay Kumar TM for appellant.
The case, ಇದರಲ್ಲಿ matter has been settled, maybe settle ಆಗ್ತದೆ. For that reason I'm
Memo is filed stating that the dispute is settled before the trial court. If nothing survives for consideration in this petition, he wants to withdraw the same. Accordingly, dismissed as withdrawn.
Much.
Yes.
Cell number 19 adjourned. Cell number 20.
No,
20.
no representation for dismissal tomorrow.
Cell number 21. Pawan HK.
Seeking transfer of MC case from Principal Judge Family Court,
What is that?
Shivamogga to Davangere, my lords. Seeking transfer of petition from Shivamogga to Davangere.
Distance?
Wife, my lords.
Distance?
Distance is approximately within the 80 kilometer or 100 kilometers, my lords. Because wife is already 100 kilometers, my lords. Already in the before the Davangere court, my lords, there is already 2 petitions are pending.
What are they?
One is for maintenance and another one is 498A case against the husband, my lords. And as wife is unable to with the financial and also on the
Children?
one daughter, my lords.
Age?
8 years, my lords.
Stay is there in this?
Yes, my lord, stay is there. And in the last date of hearing, service of notice is also stands satisfied, my lords, to the
When was the
respondent.
stay granted?
It was granted in prior to my lords.
By 4/20/24. The present petition is filed seeking transfer of MC number 303 of 2022 pending on the file of the Principal Judge Family Court at Shimoga to the Family Court at Davangere. The petitioner before this court is a wife. The facts of the case are the marriage has taken place at Shimoga on 29/5/2013. In the wedlock, they are blessed with a girl child on 2/3/2014. In view of the differences between the parties, on 30/11/2012, the husband has filed a petition seeking dissolution of the marriage on the file of the family court at Shimoga. Wife had given a complaint under section 498A at Davangere Women Police Station on 2/12/2022 and also filed an application under the section 12 of the Domestic Violence Act on 15/3/2023, that is criminal miscellaneous number 251 of 2023 before the 4th Additional Civil Judge and JMFC Davangere. It is submitted that she has to take care of the child, and also the distance between both the places is about 80 kilometers, and it's difficult for the wife to travel all the way from Davangere to Shimoga. Next para. Notice to the respondent is held sufficient by this court by order dated 24/2/2025. Next para. Having heard the counsel for the petition, there is the material on record. Considering the fact that already 2 cases are pending in Davangere and the distance between both the places is about 80 kilometers, court deems it appropriate to allow this petition. Accordingly, so and so is withdrawn, so and so the wife shall cooperate.
Much of my lords, distance may kindly be considered as 100 kilometers, my lords. It is
100
mentioned in the petition.
Yes, next.
Much of-
Item number 22. Ramesha H. for petitioner. Ramesh MS.
No representation for dismissal tomorrow.
Item number 23. Venkatesh Somareddy.
Please, petitions counsel.
Gangi Reddy BV.
Please. Well, that is such a case where kindly see initially there is a transfer petition from transfer of the case in Sagara, Shivamogga district to Mangaluru is a prayer.
Distance?
Distance between Sagara and Mangaluru is about 150 kilometers. The grounds are like this. Wife is before this honorable court, divorced wife. Well, initially a divorce petition was filed and divorce has been granted, page 99. That is by the family court at Mangaluru. Page 99, petition filed by the petitioner, that is the wife, against the husband of so and so is allowed. Next, very important thing is page 100.
1 minute. MC 5 of 2015.
Please.
Filed by the wife is allowed on
5th February 2016. And one condition is divorced. Second condition is page 100, second para. Property bearing survey number 513 measuring 9.28 acres situated in so and so Sagar Taluk standing in the name of RW1 husband, holding that PW1, that is the wife, having equal right, hereby directed to sell the said property out of sale consideration, share 50/50. This property is now the subject matter. This was challenged by the husband before the honorable division bench, my lords. Kindly see page 127. This is what the division bench of this honorable court holds. That is page 110. It starts judgment dated 17th February 2022 in MFA number 7790 of 2016. This honorable court division bench holds, my lords, order is out of the family court is confirmed. In the circumstances needless to observe, encumbrance, if any, created with the subject land shall be suggested towards the share of the appellant, and no further encumbrance shall be created. Our allegation is husband is encumbering that property. Now, on this honorable court, no further encumbrance. Page 128 made clear that both the parties are entitled to enjoy the benefits and use of fruits. It has to be sold equally. It is the order of the learned family judge. It has been confirmed. Now, suppressing this, husband goes to the civil judge court at Sagara, files a civil suit in Sagara. Your lordship may have to kindly excuse me. It's in Kannada, page 16. Only case number, OS number, page 16. OS number 12 of 2024. At the family, at the civil judge senior division Sagara.
46. The relief.
Relief is for a declaration that he is the absolute owner of the very same property, and to restrain the wife from interfering with this possession. And he obtains an expert interim order. This is in the 2024.
Nothing has been stated about
No.
the proceeding.
Nothing has been stated.
Injunction is granted when?
Please, one your lordship's question, my lords. He states that the divorce has been upheld, and despite this, he seeks the very same relief of declaration.
No.
Injunction is granted.
Injunction when?
Injunction, date of the order of injunction, my lords. Please, my lords. Dependent placed ex parte. Sorry, my lords. Not earlier, later. Entitled complaint was the FIR number.
Page 35.
35. Please, my lords.
Date of
35.
the order.
Please.
Date of the order 8/7/24.
35, 8/7. Restrained from so and so. In fact, this honorable court said both are equally entitled.
Only disposition. Only disposition, that's all.
Whatever
That is only the interim order.
Dispossessing. The question is, this honorable court again said both are entitled to enjoy the properties. Now the question is this under section
Injunction against the co-owner.
Against the owner, wife, co-owner. Now, my lords, now family court at Mangalore where judgment has been passed is the court where any execution petition has to be filed. Section 7 clearly provides in Family Courts Act any matter between the parties in respect of husband and wife and the immovable property has also been decided. It has been rightfully decided. The only question is, my lords, sale of this property. If he has any grievance of the sale or the mode in which it has to be done, he has to go back to that court for dealing with it. He cannot have another relief that too overreaching the orders of the honorable court. And the declaration what is, I am the absolute owner. Therefore, one prayer we have made is to transfer this, my lords. We have also filed a writ petition now, my lord, challenging the very proceedings that it requires to be quashed because it's clearly an act of overreaching the orders of the honorable court, suppression, etc. My lords, such a suit itself is not maintainable. Now, my lords, one prayer would be, my lords, exercising inherent jurisdiction, whether such a suit can be allowed when it comes to the kind notes. I do understand. I understood. I am grateful, my lords. Second is, my lords, pending other consideration of my prayer for quashing or whatever the relief I may seek before the family court after the transfer, my lord. This has to be transferred to Mangalore court, my lords. And originally it was there. This is not the way.
Yes, what do you say?
But here, she sought to transfer the case from Sagar to Mangalore court, family court. The property is situated at jurisdiction of the Sagar court. Maybe it will be 240 kilometers from Sagar to Mangalore. But she suppressed, she says in the petition that she is a resident of Mangalore. She is a junior engineer working in Nanjangud, Mysore district. Now she is presently working in Nanjangud. She is from Nanjangud to Bangalore. There are some to nearly 150 kilometers are there, my lord. Now, my lord, she is working in Nanjangud, Mysore district. She sought transfer from Sagar to Mangalore, just to only harass the respondent. He is a farmer. His life depends upon the agriculture. She is employed. She is earning more than 1 lakh rupees as a salary. She wants to give harassment to the respondent. That's why she filed a petition. Well, of course, my lord, he filed a suit for declaration and injunction. Of course, there is a wrong. I already advised the counsel who appear in the court to modify the prayer in the suit. Only they can file a suit for injunction, not for declaration, because both of you got a share in that.
Can you file a suit for injunction also? Can you maintain injunction suit? In the light of the order passed.
Not to disperse us, because they are troubling me.
It is, you have to sell the property. That is what is the order of the court.
So she's troubling me, my lord. Every time she bring the rowdies and in fact, I have stated in my accept objections, my lord.
But she's the co-owner of the property as per the order of the division bench.
No, my lord. She has got a half share. I can understand. I can understand.
She's doing anything. At best, you can give a police complaint.
Well, I have made a police complaint. There is a case pending. There are 2 cases I have filed against her. She also filed 2 cases against me. All the 4 cases are pending in the Sagar court. 4 criminal cases are pending in the Sagar court.
What do you say about his submission that you're working in Mysore?
My lord, she has been permanent resident in Mangalore, but it's a transferable job. Earlier is in Mangalore.
Permanent resident.
Now, my lords, she has been.
Yours is a transferable job.
No, my lords, mine is a transferable job. Even at that time, my lords, when the case was filed in Mangalore, my lords, she was initially in Mangalore district, my lords, then transferred to Hassan district, my lords. From there, another district is now being transferred, my lords.
No,
my lords,
the purpose is, what is the purpose
prime
of
point is, my lords.
Mangalore?
Prime
you're
point
not
is,
in Mangalore.
Please, may I submit, my lord? Prime point is, my lords, when the originals matter is from the family court Mangalore. Any further proceedings therein, my lords, can only be taken in that court unless they move for transfer of that case itself. Original case is in Mangalore. Any other relief to be got?
According to him, according to him, the cause of action is something else.
No, my
There
lords.
is nothing related to this.
No, my lords, kindly.
No, the
I
next point
understand.
is, the next point is, in a
Please.
transfer petition,
Please.
court will not decide the legality or otherwise of that proceedings which are initiated.
My lords, as far as this point is concerned, my lords, now can there be an independent proceedings in another court be instituted, my lords? One.
He has filed a suit.
No, my lord, suit.
Whether the suit is maintainable or not, I cannot decide in this transfer petition. You have your own remedies to say
Please,
that
please.
that suit is not maintainable.
Please.
And that has to be, the plaint has to be.
No, my lord,
returned.
if this is the argument, my lords, that she is now working Chamarajnagar. Chamarajnagar from Chamarajnagar is southernmost part, Nanjangud of
But
Karnataka.
because in that case, what
of
happens is
Karnataka.
you cannot, because you have a transferable job,
Please.
you can't ask the matters to be transferred wherever you are.
No, my lords, question to me, my lords, about the legality of the proceedings, my lords. The writ petition is filed before this honorable court, my lords, in WP number 4807 of 2025, my lords. Would your lords be kindly permit us, my lords, to agitate the matter therefore the matter has not come up?
This matter also to that.
Pardon me, my lords.
I'll tag on this matter also to that.
As your lordship holds, my lord, that matter be come up before, so that matter can be
What is
disposed.
that number?
WP 4807 of 2025.
WP
4807.
of 2025.
Please, my lords.
The present petition is filed seeking transfer of the OS number
12 of 2020.
2024 pending on the file of the additional senior judge and JMFC Sagara to principal judge family court at Mangalore, Dakshina Kannada. It is submitted with the senior counsel that in respect to the very same property, the rights of the parties are crystallized by the family court, which is affirmed by the division bench of this court in MFA number 7790 of 2016. It is submitted that such a suit is not maintainable, and in that regard, they have already filed a writ petition before this court, that is 4807 of 2025. In that view of the matter, in the particular facts and circumstances, the registry is directed to obtain the necessary instruction of the Honorable Chief Justice, tag this matter to WP number 4807 of 2025.
Please.
24.
May I pray the honorable court kindly extend the interim order which is not.
Earlier interim order earlier granted is extended till the next date of hearing.
Grateful.
Till number 24. Not H for petitioner. Kumar.
Yes.
For respondent.
Yes, from where to where?
Lordship, last date, the honorable court direction given to produce the
Proceedings
entire
of the trial
ordership.
court.
Ordership.
Yes. Take that.
But on 4/11/2024, 21/9/2024, the
PW1 is examined.
examined
in
and
part.
examined partly, my lord.
So trial has commenced.
A trial has commenced, my lord. The reason for transfer is, lordship, the petitioner is getting severe hip joint pains during travel and even to walk, my lord. He cannot sit more than 15 minutes on the chair, and the doctor has given advice.
He has to attend the court where the case is there. Also, he needs to be in the court for hours together.
My lordship, the wife has filed one more petition in Mandya, my lord. The 498 petition is also kept for petitioner evidence, complainant evidence. She has filed one more divorce petition in Dodbalapur.
No. What are the cases pending? One is MC.
One is MC filed by the wife in senior civil judge, Dodbalapur.
Dodbalapur filed by husband.
No, my lord, wife. Divorce petition filed by the wife in
Dodbalapur. And what are the other cases?
Another petition for 498A is filed by the complaint filed by the wife.
That's also
Mandya Women's Police Station. Lord, it's a CC number 3192.
That is Dodbalapur.
No, my lord, in the Mandya itself.
In Mandya.
Mandya. And another Criminal miscellaneous petition 358 of 2020 also filed by the wife. 358 of 2020, my lord, for maintenance filed by
What
the
is
wife
that?
in Dodbalapura, my lord. They're also seeking for a transfer of that petition. Yesterday it was, notice was issued, my lord. And the criminal petition,
What were you doing from 2022?
21 she filed, my lord.
23?
21 she filed for this one complaint, my lord. 2020 she filed maintenance. After getting 20,000 maintenance, she filed divorce petition.
There all through.
No, my lord, he is not unable to travel. The council is conducting all these stages.
My lord, there are 4 cases in Dodbalapur. One is MC, one is for maintenance, seeking maintenance. The other is for recovery of maintenance, and the other is he has filed for challenging the CMIS, that is seeking for maintenance. So there are totally 4 cases
What is
pending.
that he challenged?
He has challenged the maintenance petition.
Granted.
Yes.
So he's contesting there.
Yeah, he is contesting there in Dodbalapur only.
What
So
is
there
the
are,
stage now in that at Dodbalapur?
sorry, my lord,
MC, at what stage?
partly crossed.
Partly crossed.
Yes, ma'am. And moreover,
PW1 or RW1?
PW1.
Mm.
And moreover, the petitioner is working in Bangalore, and it is only 40 kilometers from here to Dodbalapur. Therefore, his hometown may be Mandya, but he is staying and working in Bangalore.
Have you filed your objections?
I have filed yesterday. I don't think it is being put up.
Matter tomorrow, along with the objections filed with the land council respondent.
Serial number 25 adjourned.
Much.
26 Rangaramu V. Rangaramu V for petitioner B. Sharat Kumar.
I filed the affidavit, please, Mats, stating that I have been residing at Nanjangud. The petition is filed by the.
6.1, you're taking notice?
Please, well.
In 26.1, B. Sharat Kumar is.
Please, I'm missing.
So you're taking notice on in 26.1.
Not in this case.
There appears to be connected matters. Look at the cause list.
Now in that case.
You have filed CP 140.
Please, Mats, I have filed the notice number connected.
You're not aware of it?
Not aware.
Serve him copies. Then counsel Mr. Rangaramu V takes notice on behalf of the respondents. When do you want?
After 2 weeks, I have to look into it. I'll file my objection. And also.
It's a matter after 2 weeks with the objection
and
of the.
also regarding, yes, filed the
History
counter.
is directed to print the name of Mr. Rangaram. Yes.
Counter of it filed by him, there is a, according to him, there is a annexure R1 is filed. But copy not
It is
so.
with them.
Yes.
Copy not so.
Let's give a date. Please. Yes, next.
Serial number 16-4. Serial number 27 Ishvara.
That's for petitioner, my lords. The petitioner here in seeking transfer of MC number 175/2024, which is the dissolution divorce petition filed by the respondent herein from Bangalore to Mandya, my lords.
Bangalore to Mandya.
Mandya, 100 kilometers, my lords. Distance is 100 kilometers, approximately a 2.5 hour journey, my lords. My lords,
What are you doing in Mandya?
My lords, Mandya, I'm residing with my parents, my lords. After desertion.
Your children?
No, my lords.
Yes.
My lords, the respondent, my lord, is gainfully employed in Bangalore.
In Bangalore.
In Bangalore, she was working as a senior test engineer at Mindtree L&T.
My lords, my
Subsequently, my lords, may I just pass on
So
this
file your
screenshots, my lord. I filed my objections.
Let's see.
Please.
When were these objections filed?
20th of March, my lord. Filed it in the registry. I've supplied copies to the petitioner.
My lords, my instructions are presently she is prior.
They're not instructions, sir. You have to file your reply to this. We joined it to
We will
this.
file affidavit. Then we will.
May I
file
just
affidavit.
seek one indulgence, my lord? Your lordship may kindly look at the screenshot.
If that's the case, tell your client, will direct the registry to initiate perjury proceedings for making false statement before the court.
No, my lords, we will
At the
file
time of
affidavit.
marriage, my lord, in the matrimonial had, it says, my lord, that she was working as a senior test engineer. Your honors may look at the last sheet, my lord.
Hmm.
Her name is forthcoming in the website. She's part of the team, my lord. That company's name is Avis Networks.
We'll
It's
give
a
her an
AI
oppor-
company.
We will give her an opportunity. Land counsel for the petitioner submits that she is residing in Mandya along with the parents, and the objections are filed with the respondent stating that she is working in L&T.
L&T, my lord. Now currently she's working at Avis Network. And it's a AI company, my lord. The branch office in
What is the spelling?
AVIZ.
AVIZ Network at Bangalore.
Bangalore. The branch
And,
office is in Bangalore.
And the present petition is filed with incorrect facts. The the petitioner shall file an affidavit before this court, adverting to the allegations that are leveled in the objections filed by the respondent, and basing on that, appropriate orders will be passed.
I'm so grateful, ma'am.
It's interim order earlier granted, may kindly.
Interim order earlier granted is extended till then. When will you file?
It's any date by next week, my lords.
15?
Very well.
Please, ma'am.
Yes.
Serial number 28, Ravi Shankar N.
Yes.
For petitioner.
For the petitioner, Lordship. This is a transfer petition from Anekal to Bangalore, Lordship. It's about 30 kilometers from here, ma'am.
Huh?
It's about 30 kilometers only. She was staying there for 5 years there. Physically, they are separated for almost 6 years. If you see the order sheets also, not much of progress has happened. She has found an employment here. She's working for a company called American Filters, and she wants to either settle the matter in Bangalore or need to, so that she wants the petition to be transferred to Bangalore.
Why there is a scope for settlement?
I have a feeling that there is, because it's almost 6 years of settlement.
Shall we refer this matter to the mediation?
Can be.
Both the counsel submit that the matter can be referred to the mediation. Both the parties shall appear before the Bangalore Mediation Center on 7th April. 7th April at
Please.
3 p.m.
Returnable by Lordship.
Registered Judicial is directed to communicate the same to the
Just in case when something happens, can this be returned to this court?
Yes, it will again come.
It will come back.
If it is not happening, it will come.
7th April.
7th April. Great. Obliged.
Number 29, Mohan BK.
For petitioner, my lords.
Yes.
My lord, this is a transfer petition where I am seeking transfer from Bangalore to Mysore, my lord. In fact, the respondent, he himself has filed a GNW petition in Mysore. And within a span of 1 month, he goes to Bangalore and files a dissolution petition against me in Bangalore, my lords. And I have a child of 6 years and I'm unemployed, and currently I'm residing in Mysore, my lords.
It's coming up for the first time.
Yes, my lords. No, previous it had come, my lord. I had sought an adjournment as I was not in town, my lord, on that day. Otherwise, for hearing, it is coming for the first time, my lord.
So, GNWC is of which year?
It is of 24 only, my lord. He files in the month of October.
MC?
MC is also 24, my lord. He files it in Bangalore.
Which month?
October, my lord. September 2024, he files a GNW petition in Mysore. And October 2024, he files a dissolution petition.
The petitioner, the present petition is while seeking transfer of MC pending on the file of the family court at Bangalore to Mysore. Bangalore to Mysore. It is submitted that initially husband has filed JNWC on the file of the family court at Mysore in the month of September 2024, and thereafter he has filed the MC in the month of October in Bangalore. It is submitted that the wife is residing in Bangalore and Mysore, and it's difficult for her to travel. Distance is 150.
Yes, my lords. And she has a small kid of 5 years, my lords.
Distance between Mysore and Bangalore is 150 kilometers. Next para, considering the fact that already a JNWC is pending and the distance between the places is about 150 kilometers. There shall be stay of all further proceedings. Take out hand summons.
Grateful, my lords.
On the counsel for the respondent, file a memo to that effect by 15. If it is filed by 15th, the list is marked on 16th, or else the stay granted by this court stands vacated.
Yes, my lords. Grateful, my lords.
Serial number 30, adjourned. 31, Abhijit.
For the petition.
For petitioner.
Seeking for transfer the petition pending before the Bangarapete court to Beltangadi.
Where is that?
Bangarapete to Beltangadi. It is a 450 kilometers. Also, I have a small child, 2.5 years baby.
There's no maintenance order was granted till today.
No, which case it is?
31.
31.
I have filed the divorce petition before the Veltangadi.
Hmm.
After that, the respondent has filed the conjugal rights petition before the Bangar pattern.
No.
Difficult to travel.
Let me just look at the prayer. To transfer MC number on the file of the principal KFC, Kolar.
Sitting at Bangar pattern.
Kolar to the learned principal senior at Beltangadi, where MC number
70.
MC 75 2024 is?
Beltangadi.
For what?
A divorce. Resolution.
Divorce. Both are divorce.
No, that is the conjugal.
Conjugal rights are filing.
You filed conjugal rights.
Bangarpet.
What do you say?
Kindly refer to mediation and settle the matter.
In Beltangadi is okay.
Huh?
Beltangadi is.
The respondent.
There's a mediation center there.
No. But
You have to go for the mediation where there is mediation center.
there is a far.
Wherever it, Beltangadi is
South
where?
Kenya.
Huh?
South Kenya. Mangalore.
Mangalore. So then Mangalore Mediation Center.
Please.
You are staying where?
Bangarpet. I'm doing coolie.
Either driver.
No, for everything you can't ask her to. If you want interested for mediation, go to Bangalore Mediation. Both the
She has small child, man, 2.5 years, baby. Without support, she can't travel.
Both the parties shall appear before the Mangalore. It is submitted that there is a scope for settlement. Both the parties shall appear before the Bangalore Mediation Center on 15th of April. At 15th of April.
The interim order will be extended.
Registrar Judicial is directed to communicate the same. Interim order earlier granted is extended. Yes.
32.
32 is adjourned.
32 adjourned. Serial number 33. One and DS for petitioner.
Not seeking transfer proceeding from Tarikere to Chitradurga, around 90
From?
km. Tarikere to Chitradurga, 90 kilometers is there. Tarikere is in that is the place.
Some of the names I'm not able to
Yes.
understand it.
Okay.
Tarikere.
Yes. After filing divorce petition, my lord,
To the JMFC Chitradurga.
Yes.
What's the distance?
around 98 kilometers, 90 kilometers. I have said so.
The present petition is filed by the.
Husband,
Why you are seeking transfer?
become not, I'm not, there is harassment lot of by the,
Take notice.
one
petition shall
paragraph 14 of that page 19 can be seen.
What is that?
I'm not, that is the government made divorce petition. How she has tortured me, madam.
No, whatever it is, take notice. We will not fill. Here the other side, the petitioner is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 15th of April. If it is filed, this matter on 16th.
Serial number 34. Raja R for petitioner.
Petition filed by the husband seeking restitution of conjugal rights from Madhur court to Bengaluru court, my lord. So she has to take care of the minor daughter aged about 2 years, 7 months, my lord. And petitioner is
What is the
working
distance?
90 kilometers, my lord. Bengaluru to Madhur. And
The present petition is for seeking transfer of MC number
35/24.
MC number 35 of 2024, pending on the file of the senior civil judge Madhur to family court at Bangalore. It is submitted that the wife is residing at Bangalore and the distance between both the cases is 90 kilometers. And she has to take care of the daughter who is aged
2 years, 7 months.
2 years, 7 months, and it's difficult for her to travel. Considering the same, they shall restrain of all further proceedings. Same, hand summons by 15th, memo by 15th, 16th, if it is, this is the matter on 16th, or else the stay granted by the court stands vacated.
Serial number 35. Chardamba AR for appellant. ASP by
Respondent number 2.
Implead petition is already ordered in this.
Please. He is appeared through advocate, my lord. Bhimai appears for the impleading appeal.
No, that's what I'm saying. IA is ordered or not ordered?
Allowed, man.
Allowed, application is allowed.
It is submitted by both the parties that all the matters pertaining to this acquisition were already allowed, several appeals were allowed by this court, and the matters were remanded back to the trial court. In the light of the orders passed, there are other matters which are allowed. Take that order from KA. In the light of the earlier orders passed by this court in MSA and other connected matters, this appeal is this court is allowing this appeal, and accordingly following so and so, the order of the reference court dated in so and so is set aside, and the matter is remanded to the reference court for fresh consideration. The beneficiary shall be pleaded as respondent before the trial court, and there are certain other conditions. Take that order and.
Number 36, Balraj H. for appellant, Kumar Swamy N.
Against the order of remand, my lord, this appeal, second appeal has been filed, my lord.
Will all these MSAs will give some other date?
Please.
Because there are so many matters for final hearing. This is coming up for what? Admission.
Admission.
Admit. This is matter for final hearing. And call for the TCR. Yes.
Till number 37, same.
Same. Admit. Post for final hearing.
Till number
Call for the TCR.
For respondent number 2 and 3, my lord.
Respondent number 1 in this case, my lord.
Lord, the respondents number 2 and 3, they have moved for moved before the trial court, my lord, for withdrawing the amount that has been deposited. Pray for staying of the further proceedings.
My lord, the question, short question is, my lord, the appellant as well as respondent number 2 and 3 have purchased the property, half of the property, my lord, by virtue of 2 sale deeds, my lord. It is not disputed, my lord. And also after service of summons notice by the land acquisition SLAO, both are not appeared, and 50% of the
MSA is filed when?
Lord, MSA is filed on 8 July 2024, man. 8 July 2024.
The state petition is not heard till now.
No, my lord. Previously, my lord, I had filed MFA, my lord, instead of filing MSA. And that case need to be disposed, my lord, and subsequently I filed MSA.
Give the file.
let him serve a copy of appeal memo, my lord. I don't have copy. If that being, I will file objections.
We'll hear it on Tuesday. Give
Yes.
him a
Yes.
copy of the appeal
Let him
memo.
file copy, my lord. I will file
Counsel for the
objections.
appellant should serve a copy of the appeal
Achha.
memo. The counsel for the respondent has served the copy of the appeal memo on the counsel for the respondent. This is matter on Tuesday.
Lord, Wednesday, my lord. Lord, Wednesday onwards, my lord.
Wednesday happens to be
Wednesday or some other day, my lord.
2-4. Wednesday.
Any day after Wednesday, my lord.
third.
Third.
Yes.
Okay.
Yes,
Number
next.
38,
My lord, the records have to be called. Records have to be called, my lord.
No, for hearing again, for the stay, we don't require all the records. Yes.
cell number 38, K. Shashikant Prasad.
For appellants, my lord.
I request short accommodation.
Only simple point, my lords, is that whether the admission, on the basis of admission, under Order 12, Rule 6, my lords, trial court has passed
Respondent
and
seeks a short accommodation. This is matter on 21st of April.
third, my lord. Because not even a single rupee, my lords, from 2008, they have paid, my
Many
lords.
matters, the court won't be
If
able
my
to
lord
hear.
pleases, it may be listed on third or fourth.
9th.
9th April.
Yes,
Cell
next.
number 39, MC Nagashri for appellant. MC Nagashri.
No representation for dismissal tomorrow. Yes, call the third list.
List number 3, cell number 1 adjourned, cell number 2.
In second list, my lord, serial number 14, my lord, it has been posted for tomorrow, my lord. There is an application to bring LRs, my lord. So only because one of the contesting, who was the plaintiff, my lord, is LRs, my lord. They have been served, my lord. If it is allowed,
Not there, I think.
just I came, my lord, that's if it,
IA number 1024 to condone the delay. setting aside the abetment and you're bringing LR, so the LR application notice to be ordered.
Yes, a notice ordered and it has been served, my lord.
Pass over, take this 14 bundle. It is here.
It's a suit to execute the gift deed, my lord. The suit was filed to execute the gift deed, my lord. It's only on.
Anyhow, we are on this delay application.
Yes, ma'am.
All are served.
Served, my lord. All are served.
IA number 1 of 24 is filed to condone that's a delay of 65 days in filing the LR application. IA number 2 of 24 is filed to set aside the abetment. And IA number 3 of 24 is filed to bring the LRs of the deceased R1 on record as R1A to E. And this court has ordered notice and all the respondents are served. No wakalat is filed. No wakalat is filed.
It's all R1, my lord. The original plaintiff is represented by counsel, my lord. He is still on record, my lord. Now for the LRs, they have not yet filed wakalat.
The wakalat is not filed on behalf of the R1 A to E. Considering the reasons stated, the delay of 65 days in filing the LR petition is condoned. Consequently, IA number 2 and 3 are also allowed by setting aside the abetment and permitting the petitioner to bring the LRs of the deceased R1 to plead them as R1A to E. Accordingly, all the IAs are allowed and the petitioner should carry out the necessary amendment to the cost type.
I'll file. It may be taken up next week, my lord. Next week, my lord, because the court has remanded the matter and it may be taken up next week, my lord.
Within a week's time, we shall file the amended cost title. Once amendment is carried out, this is the matter.
List number 3, serial number 2.
For second respondent. It was here only, kindly pass it, maybe disposed of.
Pass it.
Please.
Serial number 3, NS but for appellant.
Second respondent. Second respondent.
18 matters will not hear. We'll hear matters from 13 to 17.
Correct. I am for the second respondent.
No, that's correct. It's an appeal of 18 will not hear. That is only now oldest to 17 is the cutoff. List this matter on. We'll give 2 matters a day for the final hearing from June. On 2nd June. And you just write down how many matters are being granted. 2nd June.
Second
June.
June.
Yes.
Serial number 4,
Yes, where is Mr. Krishna Swami?
A.N. Krishna
Appealing
Swami
for
for
respondent
appellant.
to in the
Pundika
first matter,
Ishwar
my lord.
Where are the advocates? Where is Mr. Krishna Swami?
Krishna Swami is in the.
13 matters also not coming.
Kindly pass.
Pass over.
Pass over,
Whether
my
they
lord.
are there or not, I'll pass orders. Please
Please.
tell all of them. Even if none of them are turning up, I'll look at the file and pass orders. 2013 matters will not be adjourned. Yes, pass over.
Number 5, HR Renuka for appellant. Gopal Krishna N.
Happy for responding in this case, my lord.
This also pass over.
Yes, please, much obliged.
Serial number 6,
Why not even they're not coming and representing the insurance council right from the morning? Yes,
serial number 6,
pass over.
serial number 7, K. Shashikant Prasad.
Pass over.
Serial number 8, Atal D. Karagowda. A.N. Krishna Swami.
Pass over.
Serial number 9, Gunashekhar R.
I appear for respondent number 1.
P. Baldare.
I appear for respondent number 1, my lord.
I am for the respondent number.
Ready, my lord.
Yes, where is the petitioner?
Appellant.
Appellant.
Gunashekhar.
Pass over. We'll hear whether they are there or not in the afternoon. Please come. We'll pass orders.
Serial number
Yes.
10, Gopal Krishna N. for appellant. D.H. Sridhar.
This case appear for appellant, my lord. Lord, I appear for appellant in this case, my lord. Kindly may have it tomorrow, my lord. I need some TCR papers. The MSc trial court advocate is giving me tomorrow, my lord. Kindly tomorrow, my lord.
Please don't ask for time. Please tell your senior.
My yes, humble request
13,
tomorrow.
14 matters, don't ask for time.
Tomorrow, my humble request, my lord.
Place this matter tomorrow.
Much obliged.
Serial number 11, Mushtaq Ahmad. R. Jay Prakash for respondent.
Pass over.
Serial number 12, T. N. Vishwanath for appellant. P. B. Raju for R2.
Pass over.
Serial number 13,
For the point in 1 and
Sir Appellant A. Venkatesh.
appellants into 3 and connected matter 3 and 2.
Yes.
This is an appeal filed by the Oriental Institute.
1 minute, 1 minute. MFA 924 arises out of
3312 of 14.
3312 of 14. 925?
925 comes under 3313 of 14.
3313.
Yes, ma'am.
Now MFA 4748?
475 against Mellard 3312.
33?
3312 MVC seeking enhancement.
And other is 3312.
12.
It's a case of death or injury?
Yeah, both are
Both death, my lord.
Both are?
Both death.
Death cases.
Death case.
You are on what ground?
My lord, both are unauthorized passage in a goods vehicle. That is the main contention. Interest granted is at 9%. At least was question before this.
So please come to the order with regard to that gratuitous passengers.
Please come to page 15, para 20, my lord.
Yes.
On the other hand, learned counsel for the respondent number 2 argued by reiterating the contents of objection of statements filed by the respondent 2, also evidence put forth by RW2. Further, the counsel of respondent number 2 argued that the documents produced by the petty itself clear that the time of our deceased persons were traveling as gratuitous passengers. Hence, in view of policy conditions, the risk of gratuity was not covered in the said policy. Further, he argued that as per the version of the petition,
What is the vehicle?
vehicle is a goods vehicle, my lord.
What is the case of the claimants? Claimant's case.
Claimant's case is that they were traveling along with as a milk collector.
Along with the goods.
Dodla Milk Company.
It is a vehicle belong to the Dodla Milk Company.
Dodla Milk Company.
Along with the goods there, we milk package and cover. They have
To load the vehicle, or the owners of that.
They are the cash collector and cleaner of the assistant of the Dodla Company. Dodla Company milk was traveling in this vehicle.
Goods vehicle.
Goods vehicle.
Either as owner of the goods or if the employee of
employees of the Dodla Milk
Company.
Company.
Employees are permitted as per the
Vehicle.
policy.
1 plus 2 million.
Give the policy. Exhibit.
Policy is a package policy R3 million.
Let's see exhibit R3.
Exhibit, kindly come to the policy.
The policy. Please tell the court, where are the conditions of the policy?
R3 there.
Additional LL to
Legal liability.
to coolies.
Two coolies.
IMT 39,100.
No, my lord. Come to that policy which I have issued. First, PA cover for owner driver 100 rupees. Next 100 rupees legal liability to paid driver cleaner. That's only the premium I have collected. Legal liability to paid driver or cleaner. Whereas in the case both are dead, are the two persons traveling in the closed lorry, closed goods vehicle. So I have not collected any premium extra for extra person. It has to be established by the before the learned judge, stating that they were the coolies or cleaner of that insured vehicle.
Whom they have examined?
Yeah.
The Dodla company, have you examined anyone?
No, my
Made a
lord.
complaint, eyewitnesses complaint, who has made a complaint, he has been examined before the court, my lord.
Not the eyewitness. Now, considering the nature of the package, the insurance, you have to examine, you have to establish
Yes.
if you have any connection with that Dodla company. Unless and until that is established, how are you entitled for, you may be entitled from the owner, but not from the insurance
And,
company.
The appellants, the claimant, the dependents of the deceased. From the beginning, they are the employees, that has been urged before the court, my lord. Against that, they have not denied this contention.
It's not that.
And
Policy-
the
No.
milk, Dodla milk material packages is as seen at the time of the vehicle.
That is correct.
That is,
No, what is to be established is you're traveling in that vehicle as so and so of that Dodla milk company. Unless and until you establish that it is a goods vehicle, you cannot travel in that. For that, you need to examine somebody. If you do not examine, it's not because the financial burden lies on you to prove that so and so is traveling in the vehicle which has an insurance, and the liability of the insurance you have to establish first.
They have asked the question to the eyewitness complaint at the time of the cross examination.
No,
Its
we are
answer
seeing
was,
that-
my lord,
We are seeing, now, it's a goods vehicle.
goods
It
vehicle.
has a, now, as per the policy, who are covered in a goods vehicle. You are saying that you are so and so of that company. Who-
Traveling along with the goods.
So that you have
that
to
they have to
establish.
establish.
You have to examine somebody from
Yes, ma'am.
that.
Dodla company.
Dodla company.
Please.
Unless until you do that, that's because it's your specific case that you're an employee. And just like that, if you're traveling, you're not entitled. You're a gratuitous passenger. Question of pay and recover will also not arise. Whatever compensation you need to have from the owner of the vehicle.
Pay and recover even.
Pay and recover will not apply for a gratuitous passenger.
Renacity case. Renacity case, my lord, pay and gracious case.
No.
They have to
Because
pay.
as per the judgment of the, no, as per the settled law, in Baljit Kaur's case, pay and recover will not apply.
My lord, this is circumstances doesn't arise with the trial court matter. My lord, if it is lordship is that is the case, my lord, permitted to remain in the matter. I will take the summons to the Dodla company management and examine. This.
I have no objection, my lord.
Do that.
But the period of this till remand of the matter by this court, I am not liable to pay interest.
Why?
There is already 9%. It is already granted, my lord. That is also question before this court.
No. What we'll do is we'll make that interest 6%.
Yes.
Interest 6%. So that it is some interest will get.
It's a case of.
Let
death,
them
my lord.
examine if they have proved that they are the
Death, my
employees of
In
the.
all the cases, that's what we are making it 6%. So what we'll do is, as far as the order of the court granting 9% is concerned, we'll make it 6%. And we'll set aside the order on the remaining aspects. We'll remand the matter, giving you an opportunity to examine as far as that aspect is concerned, that you are the deceased were the employee of Dodla company.
Please. Both the case.
What has happened? Who has not come today? Huh? This typist who has not come, India is not there. Have you given them a format so that it will keep it? Have you given them the format so that it will be easy? Otherwise, how can they do? Yes. Open this the insurance policy. No. Insurance policy. Agreed bidder. Orders passed in. MVC number 3312 of 2014 and 3313 of 2014. The insurance company has filed MFA 924 of 2016 and MFA 925 of 2016 respectively. Even the claimant has also filed MFA number 4748 of 2017 and MFA 4759 of 2017, agreed with the order passed in MVC 3313 and 3312 of 16 respectively. The claim petition is filed seeking compensation for the death of the deceased. It is filed by the claimants seeking compensation for the death of the deceased in the road traffic accident that took place on
13/7/2014.
It is a case of the claimant that on 13/7/2014 at about 5 a.m., the deceased were proceeding in a Tata AC vehicle and the same was driven by its driver in a rash and negligent manner. And when they reached near Chikkanahalli Gate, Honenahalli village, CR Patna Taluk, at that time the lorry was parked in the middle of the road by its driver without any indicator, and due to the same, the driver of the Tata Ace vehicle lost control over the vehicle and dashed to the lorry. As a result of the said accident, the inmates of the goods vehicle sustained grievous injuries and died at the spot. Then there are two insurance companies.
No, yes, the Sriram General is also insured with the lorry. I have insured the goods vehicle, my lord. That is the lorry parked.
They have claimed the compensation against whom?
Both vehicles.
No, as far as the Oriental Insurance Company.
I have insured the Tata AC goods vehicle. The other lorry which was parked due to some difficulty at the road they have parked, that was insured with the Sriram General. I don't know, nobody has represented them today.
Then what would be the case in respect of Sriram General Insurance?
It was dismissed.
It was?
Dismissed. Against them, 3 and 4 was dismissed.
On the ground?
They are not liable to pay.
Where is that?
Please come to para 48, page 37.
Oh, because
Yes.
the finding is the accident has occurred.
Due to negligence of my insurance.
What you have written? Grievous injuries. The claim petition is filed against the driver and against the owner and insurer of the goods vehicle, as well as the owner and insurer of the lorry.
Please.
Lorry which was parked on the road. The tribunal has given a finding that the accident had happened because of the rash and negligent driving of the driver of the goods vehicle. As such, the claim petition against the owner and insurer of the lorry, that is third and fourth respondent, is dismissed. Then coming to the liability of the insurance company, it's a case of the insurance company that they are the gratuitous passengers, and once they are when they're traveling in a goods vehicle, insurance company is not liable to pay the compensation. According to them, as per the policy, they have there is a additional PA for owner driver, an amount of rupees 100, additional legal liability to the coolie as per IMT 39, an amount of rupees 100 rupees. is paid. It is submitted that unless and until it is established that the deceased or the cleaner or are they working with the Dodla company to whom the said vehicle, goods vehicle belongs to, they are not entitled for the compensation. What is the finding of the court? Where is it with regard to your liability?
Para 51 and 52.
50.
Para 51 and 52.
52 of page 40, my lord.
Further that
The court has observed that as per the contention of the claimants, the deceased persons are working as bill collector and cleaner in Dodla Milk Dairy and the offending vehicle belongs to Milk Dairy. On perusal of evidence of PW3, who is PW3?
PW3 is a complaint and eyewitness.
Evidence of PW3, it appears that as on the date of accident, the milk pockets and boxes were being transported in the offending vehicle. Hence, the court held that the respondent company has failed to prove that as on the date of the accident, the deceased persons were traveling in the offending vehicle as unauthorized passengers, and accordingly, court had granted an amount of rupees 4,12,000 in MBC number 3312 of 2014. The court had granted an amount of rupees 10,27,000 in MBC number 3312 of 2014 and an amount of rupees 9,19,000 in MBC number 3313 of 2014. The aggrieved by the said order, the both insurance company as well as the claimants are before this court. Land counsel appearing for the insurance company submits that the passengers are gratuitous passengers. The deceased are the gratuitous passengers and the insurance company is not liable to pay the compensation. It is submitted that initial burden lies on the claimants who have filed an petition under section 166 of the Motor Vehicles Act seeking compensation. But the tribunal had fixed the liability on the burden on the has fixed the burden on the insurance company that they have to prove that they are the employees of they are not the employees of the Dodla Milk Company. It is submitted with the Land Council that no evidence is adduced by the respondent, no evidence is adduced by the claimants with regard to the same, and without there being any evidence, court cannot come to the conclusion that they are the employees of the Dodla company, and the court cannot grant compensation. It is submitted that even the interest is awarded at 9%, which is on the higher side. Next paragraph. Learned counsel for the respondent submits that the not respondent, the learned counsel for the claimant submits that the third PW3 is the eyewitness, is a complainant and the eyewitness who has given the complaint. As per his complaint, as on the date of accident, the milk packets and boxes are being transported in the offending vehicle. Basing on that, the court had rightly come to the conclusion. He submits that the compensation that is awarded by the tribunal is not a just and reasonable tribunal, and the same needs to be enhanced. Next paragraph. Having heard the land counsels on either side, peruse the material on record. There is no dispute about the fact that the vehicle is a goods vehicle and the employees are covered as per the policy. It is nobody's case that it is a case of the claimant that they are the employees. It is a case of the insurance company that they are the gratuitous passengers. The initial burden lies on the claimants to prove that they were traveling in the said vehicle as employees of Dodla company, and if they want to, if anything, then the burden shifts to the insurance company. In this case, the claimants have failed to discharge their initial burden wherein, and the finding of the court that basing on the evidence of PW3, that as on the day, on the date of accident, because in the said vehicle, they were transporting the milk packets and other stuff, it cannot come to the conclusion that he is an employee of Dodla Milk Company. And such a finding of the court, holding that they are the employees, is without any evidence, is contrary to the evidence on record. Land counsel for the claimant submits that if an opportunity is granted, as this is a case of death, they would be examining the Dodla company with regard to the fact that these people are working, the deceased were working with them, considering the fact that this is this is a case of death. So this MVCs are of the year 2004, 12 and 14. No, that is 3312. Both are 14. This is MVC of 2014. Still, this court deems it appropriate and in the interest of both the parties to remand the matter accordingly. The order dated so and so is the order dated so and so is set aside, and the matter is remanded to the trial court for fresh consideration only on the consideration on the issue of both on the issue of compensation as well as
relationship
as well as the liability of the insurance company, particularly with regard to the relationship, with regard to the employer, with regard to the relationship of the employment of the deceased with Dodla Dairy. Second, but as far as the percentage of interest is concerned, that is granted at 8%, the 9%, which is on the higher side. The court should have been, it should have been 6%. The trial court shall also look into this aspect. The parties without further notice shall appear before the court on 22nd of April, and from there on, within 1 year, the court shall dispose of the matter.
Amount in deposit may be transferred. Amount in deposit may be transferred.
Amount in deposit shall be forthwith transferred to the court. No. All are no. Their appeals are dismissed. Their appeals are the appeals. No, all are allowed and remanded. Yes. Where is that? 13.1.
2 and 3, my lord.
Any of the appeal, you can give because they're already, the liability is not on them. In respondent number 3.
My appeal, I'm seeking enhancement. Both are dispensed with the.
That's what you can file a memo. So and so, give him so and so. A memo is filed seeking dispensation of notice to R3 and R4, stating that the liability is fixed on respondent number 2 insurance company.
1 minute, please.
Respondent number 2 insurance company, according to the memo is taken. A notice to so and so is dispensed with. Yes, next.
Chair number 14, Anil Kumar M for appellant.
What, Mr. Pradeep? No representation from the insurance company in all the matters. Right from morning. Yes.
14, Anil Kumar B. Pradeep for respondent.
What is this case?
Case of death mill.
Seeking enhancement.
Enhancement of.
What is which year is the accident?
Accident mill at 14/5/2011. 14/5/2011.
2011. Age?
60 years.
60. Income?
Income 7,000 they pleaded me.
Pleaded. Court had taken?
4,000.
How much should be taken?
6,500.
2011.
1/4 deducted, my lord, that's wrong, my lord. 1/3 has to be deducted. Only 3 numbers of dependents.
How many are the
3.
3? 4 are deducted?
1/4. my lord.
1/4. So 6,500.
500.
No future prospects.
No, my lord, 60 years.
6,500 into 1/3.
Sorry, my lord, one submission, my lord.
Hmm?
Sorry for interference, my lord. In 13.3 and 4, I have not yet filed wakalat. May I be permitted to file wakalat?
Within a week.
Please, my lord.
In 13.2 and 3, Mr. M. Venkatesh is permitted to shall file wakalat within a week. 6,500 into 1,500 is 2,166. That is 4,333 into 12 into
9.
it comes to 4,67,960.
960.
Loss of dependency. Then 1,32,000 would be considered.
Please. 3.
44 into 3. 1,32,000, 36,000, 10,000. It comes to 6,45,964. How much was granted?
3,94,000.
3 lakh?
94,000.
Interest?
6%.
Please come. Agreed with the order passed in MVC number 3394 of 2011, dated 2nd March 2013. The claimant is before this court seeking enhancement of the compensation. The claimants are before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs for the death of the deceased in the accident. The claimants are the wife, son, and daughter. It's their case that the deceased is aged about 60 years, earning an amount of rupees 7,000 per month. The court on the issue of liability has said that the accident has happened because of the rash and negligent driving of the offending vehicle, and the insurance company is liable to pay the compensation. When it comes to the compensation, court had taken 4,000 as income and granted the compensation as per the table given below. You will get the table at page number 11, internal page 11. And an amount of rupees 3,94,000 is awarded. Agreed thereby, the claimant is before this court. This is an appeal of 2016, and there is no representation on behalf of the appellant. And this court proceeding is inclined to decide this appeal basing on the merits of the matter. This accident had taken place in the year 2011. As per the chart prepared by the Legal Services Authority, the notional income can be safely taken at 6,500. Considering his age of 60, he's not entitled for the future prospects. And there are 3 claimants, 1/3 has to be deducted towards personal expenses, that is 2,166. And his contribution to the family would be 4,333 into 12. And the relevant multiplier is 9. Hence, under the head of loss of dependency is entitled for an amount of rupees 4,67,964. As the claimants are 3 in number, towards loss of consortium 1,32,000, funeral expenses 36,000. In the light of the law laid down in make allowance so and so, towards legal expenses 33,000. Altogether 10,000. Altogether, the claimant is entitled for an amount of rupees 6,45,964. Accordingly, the appeal is allowed, enhancing the compensation from 3,54,000 to 6,45,964. Yes, next matter.
Interest, so far as interest is concerned, my lord, 1,053 days delay, my lord, not entitled to interest.
That is condoned on that ground.
With a condition, my lord.
This court, by order dated that.
I filed an objection,
By
my lord.
order dated, where is the order?
Order. Okay.
The delay was condoned, but as this court had condoned the delay on the condition that they will not be entitled for interest by order dated 11/2/2025. The claimant is not entitled for a period of 10 not entitled for interest for a period of 1,053 days. Yes. Next.
Serial number 15. O Mahesh for appellant. K. Shantaraju for respondent.
No representation. List this matter for dismissal next week.
9-4. Serial number 16. Shiva Reddy KN for appellant.
My lord, this
Ramesh
case,
Kumar RV.
Who appears to the
Raju.
respondents?
one Ramesh Kumar is appearing for insurance companies, hard time to verify with the officials regarding the liabilities concerned, my lord.
No, Ms. P.B. Raju is not appearing.
Raju is for R2.
Insurance company is Mr. Raju, I
Ramesh
think.
Kumar is appearing for
Sir, R1.
R1.
R1 is who owner of the vehicle, I think.
Yes, my lord.
Where is Mr. P.B. Raju? He was here. Will pass over?
Please, my lord. It is liability challenged by the owner come driver of the auto.
We'll hear it in the afternoon.
Please, my lord.
Yes, next matter.
Serial number 17. Adinarayanan.
Appeal is against the
Gurdev
dismissal
Prasad.
of the claim petition.
Give that 1 minute.
16 on the last occasion, I had made a mention to the court. The case is that as on the date of the accident, he had an LL.
Yes, sir.
He had
LL,
a
my lord.
learner's license.
Learner's finance. That you wanted to verify.
Now, he has given me the particulars. I have sent a mail also to the company. And in fact, my friend has also agreed to bear the interest component also. My company will confirm the validity of the LLR. I did make that submission on the last date of hearing. I asked my lord to have it yesterday, but they have not yet replied. My lord, can he grant some more?
Finally, we'll then take it as that there is a license. License matter on 15th, finally.
Oh, very well.
No further time will be granted.
That's more than enough.
Please, my
That day will pass on.
please, my lord.
15.
Yes, next.
Serial number 17.
Sorry, madam.
Yes.
Serial number 17.
Appellant claim petition had been dismissed on the only ground that the claimant is not eyewitness to the incident. Charge sheet is filed.
So what is that?
The claimant is a mother of the deceased.
Uh,
The claim petition made before the trial court had been dismissed only on the ground that the claimant is a not eyewitness to the
It's
accident.
not, that is, you are not discharged the that the accident has taken place because of the rash and negligent driving.
The eyewitness is also examined.
Please read that particular paragraph.
Make it clear. In page 17. Judgment, page 10. Thereafter, the body was taken Boring Hospital and
We
postmortem
will read
was
from issue numbers 2 and 3,
12. You know,
page number 15.
page number 50.
Yes.
Issue number 2 and 3.
Yes.
The petitioner attributed negligence on the part of the driver of the tractor bearing number so and so in the alleged accident and about the death of the deceased Chetan by sustaining grievous injuries in the said accident. Per contra, contesting respondent 1 and 2 denies the allegation of the petitioner. On the other hand, they have attributed negligence on the part of the deceased himself, contending that the deceased had no driving license and he is not aware of the riding of two-wheeler, and as such he sustained injuries due to self-fall and there is no involvement of the offending vehicle in the alleged accident. In view of the burden on the petitioner to prove the fact that the accident against the deceased Chetan was due to the rash and negligent actionable negligence on the part of the driver of the tractor bearing registration number so and so, by proving its involvement in the accident, the deceased Chetan sustained grievous injuries and succumbed to the same at a hospital with the necessary evidence. To prove the same, the petitioner number 1 deposed in her evidence about the accidents, stating that on 20th August 2012 at about 5 p.m., when her son was riding a motorcycle bearing so and so on Kalkere main road, and when he reached the near Ramurthy Nagara petrol bunk, slowly and cautiously by that time tractor bearing registration number MEA 6987 driving by its driver came on at high speed in a rash and negligent manner and dashed against the vehicle of her son and caused the accident, and due to the same her son sustained grievous injuries. She further deposed that immediately the accident was taken to Manasa Hospital and then to Koshish Hospital, but her son died during the treatment without responding the same. Further deposed that thereafter body was taken to Boring Hospital and postmortem was conducted by, and the body was handed over to him. They have conducted.
What is the date of the accident? When is the date?
Same. And 28th August 2012.
28th August 2000.
20th.
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 Hmm.
20th August 2012.
Then come to the exhibits. What are the exhibits marked?
Exhibits.
When was the FIR registered? What?
Same day.
Time of accident?
Everything is not disputed.
Please tell the court.
Mala. Evidence. Exhibit 1 is the FIR.
Please look at it. Pass over. Yes, next.
Serial number 18. Serial number 18. O Mahesh for appellant. Yes, Raju.
Is this working? Over there online, you see. Password.
Serial number 19.
Password.
Serial number 20. Satish HK. 20 Satish HK.
For the appellant in this case. Well, Respondent Corporation of.
You're the claimant.
I am for the Respondent Corporation, my lord. The Tamil Nadu State Transport Corporation. My lord. It is the two appeals filed by the claimants and two appeals by the corporation. My lord.
Yes.
On the ground of negligence and, my lord, in this case, the two vehicles are involved in the accident. My lord.
There are two claim petitions.
Two claim petitions.
So MFA 6727 is arising out of MVC
1495 of 2010.
14.
95 of 2010.
Then MFA 6677.
6677, 1495.
1495. Then 6678.
78 to 2357 MEC.
20.
2357.
Of 10.
Yes.
10 only.
And yours is also same. 2357.
Yes.
These two are cases of death or injury.
Injury, my lord. Case of injury, my lord.
You are on what ground?
And on the ground of negligence, my lord. Mainly on the ground. The two vehicles are involved in the accident. My lord. Bus and rider of the motorcycle, my lord. The rider of the motorcycle came to the wrong side, dashed against the left side front portion of the bus, my lord. The manner of the accident clearly shows that the rider of the two-wheeler himself is responsible for the accident. My lord.
Negligence or completely denying the negligence on the part of the driver?
Contributory, my lord. Contributory.
Please come to that discussion. Which issue?
My lord. Para 12. Petition. Petitions have produced police report in Exhibit P1, first information report, Exhibit P2, the translation and charge sheet, Exhibit P3, translation P3A clearly shows that petitioner sustained injuries due to the negligent driving of the bus. Looking to the cross-examination of PW and PW3, nothing is elicited to hold that there was fault on the part of PW and 3 at the time of accident. In riding the motorcycle, PW in his cross-examination also says that they were on the left side of the road and they had parked the motorcycle to go to nature call. PW clearly states that accident took place when he was about to stop the motorcycle. The bus came from opposite direction and dashed the next para 13. Respondent has examined RW1. The driver of the offending bus, he said that on the 3/12/2009, he was driving the bus bearing so and so from Duncan Kote to Thali slowly and carefully. When the bus reached near Muneshwara temple of Tippen Agrara, a two-wheeler bearing number KA51K8375 came from opposite direction in a rash and negligent manner. He states that motorcycle came from rear side of the bus and the rider was trying to overtake the bus. At that time, the rider of the two-wheeler and seeing another two-wheeler coming from the same side of the bus suddenly took his turn his vehicle slowly towards right side. There was accident. RW has tried to state that he was driving the above said bus slowly and cautiously. In the process of overtaking his bus, the rider of the motorcycle caused the accident. When he tried to turn his vehicle towards right side and seeing another two-wheeler coming from the opposite direction. But in the cross-examination, he admits that police have filed charge sheet against him, but he states that he do not know that police have filed the charge sheet against him since the accident is due to his fault. Still, then he states that he do not know anything about the charge sheet filed by the police against him. But in this case, sketch and IMA report is crucial. Exhibit P4 is the sketch, my lord, and Exhibit P10 is the accident register extract, my lord.
You have examined the driver of the vehicle.
Driver of the bus.
And the FIR, the charge sheet is filed
Is
against.
filed against the bus only, madam. Exhibit P10 register, accident register extract.
Where is that? Yes,
Exhibit P10 accident register may kindly be seen, madam.
P10.
P10 is the damage sustained to the left side front portion of the bus, my lord.
1 minute. What is the age of the claimant?
20.
Huh?
20 years, my lord. Both 20 and 21 years.
He was riding the vehicle.
Yeah, he was reading the.
He was having a driving license.
Yes, ma'am.
You said P?
P10, my lord. That is accident register extract.
P10.
The left side front portion of the bus has sustained damages. Ma'am.
P10 is not, there are no photographs.
Accident register extract, my lord.
Yes, it is there.
ಅದರಲ್ಲಿ damages sustained to the vehicles ಅಂತ. ಇಲ್ಲ.
Where do you find all that? This is the accident.
Exhibit P10, accident register extract.
Yes, I'm looking at that. to any of these aspects has fastened the liability on the insurance company. It is further submitted that the interest is awarded at what percent? 9%.
8%, 8%.
8%, which is on the higher side. On this, learned counsel for the respondent claimant submits that the court had rightly considered the evidence on record and the charge sheet, the FIR, and all the documents points at the negligence of the driver of the corporation bus, and the court had rightly held that the accident has happened because of the negligence of the driver of the corporation bus. It is submitted that there is no interference is called for on that aspect. Next para. Coming to the compensation. Learned counsel submits that this accident had taken place in the year 2009.
3/12/2009.
3/12/2009.
2009.
3/12/2009, and it's a case of the claimant that coming to is MVC number 1495 of 2010. Coming to MVC number, give a side heading, MVC number 1495 of 2010. Coming to the compensation that is awarded in MVC number 1495 of 2010, the learned counsel submits that he had sustained 2 injuries, and under the head of pain and suffering, the amount that was granted is not a reasonable compensation. He was in the hospital for a period of 90 days, and the court had granted a meager amount under the head of attendant nourishment and transport. Further, the court had taken the income at 3,000, which is on the lower side. Further, it is submitted that when the doctor had deposed that he had sustained 22% disability to the limb, court without any basis and without any discussion had taken the disability at 10%. Further, even on the head of loss of amenities also, the amount that is granted is on the lower side. Further, coming to MVC number 2357 of 2010, it is submitted that even in this case also, the court had taken the income, the disability on the lower side and granted the compensation, which is not just unreasonable. Next. Having heard in response to that, learned counsel for the corporation submits that court had rightly granted the compensation and there are no grounds to enhance the compensation. Next, having heard the counsels on either side, peruse the material on record. The first coming to the aspect of liability, the evidence on record, that is the FIR, the charge sheet, shows as per the police records, because of the negligence on the part of the driver of the corporation, the offending vehicle, the accident had happened. Except examining the doctor, no other evidence is placed on record by the respondents. And the claimants, by placing the police records and other documents, have discharged their burden. And whereas the insurance company had failed to discharge the burden cost upon them. In that view of the matter, this court is of the view that the finding of the court with regard to the negligence on the part of the driver of the corporation bus needs no interference. Then coming to the interest part, the court had granted 8% interest, which is on the higher side. Hence, the appeal of the insurance company, that is MFA number 1495 of MFA number 6727 of 2013 and MFA number 2357 of 2000, MFA 10300 of 2012 are partly allowed by reducing the rate of interest from 8% to 6%. Then coming to the appeals filed by the claimants seeking enhancement of the compensation. First, coming to MVC number 1495 of 2010. Considering the 2 injuries sustained by the claimant, this court is granting an amount of rupees 60,000 grievous injuries. This court is granting 60,000 towards pain and suffering. The medical expenses court had rightly granted 28,965, and there are no grounds to interfere with the same. Then coming to the attendant nourishment and transport, considering the hospitalization of 90 days, this court is granting an amount of rupees 60,000. Then coming to the income, though it is stated that is earning 5,500 per day, there is no evidence is adduced. Hence, considering the chart prepared by the Legal Services Authority for the year 2009, this court is taking the notional income at 5,000 and is granting an amount of rupees 25,000. Then coming to the loss of future income, if the income is taken at 5,000 into 12 into 18, and coming to the disability, doctor has deposed that it is 22% disability to the whole body. Without there being any discussion, the court ought not to have taken 10%, and this court is taking 22% as a disability. Hence, 22 by 100 is 2,37,600. Considering 22% disability, the loss of amenities, this court is granting 30,000. And in the light of the law laid down in Mekala of so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 4,51,565. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from 1,65,065 to partly allowed to 4,51,565. The amount will carry, the entire amount, the awarded amount will carry 6% interest. Then coming to MEC number 2357 of 2010, considering the two injuries under the head of pain and suffering 60,000, as he was in hospital for 17 days, towards attendant and nourishment 17,000, medical expenses, no interference is called for. Coming to the loss of earning during the laid off period for 3 months, this court is granting 15,000. Then coming to the loss of future earning, the court had taken 10% disability without any discussion, when the evidence of the doctor is that the disability is 22%, same like in the earlier matter, 2,37,600. Loss of amenities also same 30,000, and legal expenses 10. And accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,37,805 to 3,71,305. The entire awarded amount will carry 6% interest. Any delay in this matters?
No delay.
Written for signature.
My lord, one submission, my lord. My lord, one submission. I apologize. List number 2, serial number 17, my lords. With respect to that, only one MSA, my IA number 2 for the proposed respondent, it was allowed, my lord. Rest connected, it is not allowed, my lord. If your lordship allows the connected matter, then meanwhile I will serve the copy upon, my lord.
No. We'll have call it in the afternoon. There is no purpose in posting it to tomorrow. Yes, afternoon.
Please, my lord.
Inform the other side counsel.
Please, my lord. Grateful.
ಈ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇರೋದು ಒನ್ನಲ್ಲೂ ಇದೆ
ಮುಗಿಸ್ಕೊಂಡು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮುಗಿಸಿ ಥರ್ಡ್ ಲಿಸ್ಟ್
ಒನ್ನಲ್ಲಿ
ಬರೀ ಆರ್ಡರ್ ಶೀಟ್ ಮಾತ್ರ
2 ಅಲ್ಲಿ ಇದೆ ಆದ್ಮೇಲೆ 8 ಇದೆ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅದು ಬಿಗಿನಿಂಗ್
List 1 ನಲ್ಲಿ serial number 14. 14.
Sir, along with
It is connected.
ಎಲ್ಲ ಪಾರ್ಟಿ ಅಲೋಡ್ ಅಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಎಲ್ಲ ಇದು ಪಿನ್ ಮಾಡ್ಬೇಕು. ಇದು ಎರಡರದ್ದು ಬೇರೆ ಬೇರೆ ಇದೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮೆಮೊ. 6677 ಬೇರೆ ಇದೆ, 6678 MEC ನಂಬರ್ ಬರ್ದವ್ರೆ ಮೇಡಮ್, MEC ನಂಬರ್ ಬರ್ದವ್ರೆ. ಅಂದ್ರೆ MEC ನಂಬರ್ ಅಲ್ಲಿ ಅಪೀಲ್ ಮೆಮೊ ಫಸ್ಟ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಪೇಜ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ನೋಡು, ಅದಕ್ಕೆ ಅದನ್ನು ಪಿನ್ ಮಾಡಿ. ಇದು ಅವ್ರು ಹೊಟ್ಟೋದ್ರ ಮೇಡಮ್ ತಗೊಳ್ಳಿ ನಿಮ್ದು ಡಿಪೋಸಿಷನ್ ಉಮಾದೇವಮ್ಮ ಮೇಡಮ್.
ಶಾಸ್ತ್ರಗಳೇ ಬಂತಾ?
ಹೈಕೋರ್ಟಿಗೆ ಬಂದಿದ್ದೆ, ಬಂದು ಸರಿ ಮಾಡ್ಕೊಂಡು ಬಂದೆ ಮತ್ತೆ ರಿಟರ್ನ್ ಬಂತು.
ಬಂತಲ್ಲ? ಇಲ್ಲಿ ಕೋರ್ಟ್ ಬರ್ತಾ ಇಲ್ಲ?
ಇಲ್ಲ, ಕೋಟಾ 25 ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಕೋಟಾ 25 ಬ್ಲಾಂಕ್ ಇದೆ, ಅದಕ್ಕೆ ಕೇಳಿದೆ. ಇವಾಗ ಬಂತು.
ಸರ್, ಥರ್ಡ್ ಲಿಸ್ಟ್ ಬೆಳಗ್ಗೆ ತಗೊಂಡಿದ್ದಾರೆ.
ಥರ್ಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಂದೊಂದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
Pass over matter. List number 1, serial number 4. HR Renuka for appellant. V. Vinod Reddy.
I am represented. This case, my lord, the BMTC has prepared an appeal challenging the involvement of the vehicle. Driver of the BMTC has been examined, my lord, as RW2. In para 20, there is a discussion. Internal page 12. We identify the driver of the bus in question, being number so and so examined as RW2 in this case. He has denied the entire allegation that the responsible of caused the accident and bus driven by belongs to the respondent corporation. He has categorically denied the alleged accident involvement of bus in the accident and also denied that he was responsible in causing the said accident resulting in death of M. Srinivasa. RW2 has been thoroughly cross-examined by the Learned Counsel for the petitioner. He has stated in the cross-examination that he was the driver of the bus bearing number so and so, which was playing school trip in Silicon City School. According to him, the school starts at 9:15 a.m. and closed at 3:40 p.m. According to him, since there was some program in the said school on 15/3/2012, he went to the school at 11:20 a.m. in order to bring back the children from the school. It is this case further contended that took place on bus from 7 a.m. and having fed the school to the school and left children of the school on 8:30. Since the teachers told him come at 11:30 in order to take back the children, and he went back to school 11:30 a.m. It is further contention that after dropping the children near the school at 8:30 a.m., he went to the route allotted to him in HIL. HIL from there to Oscote. After picking the passengers, return HIL dropped the passenger at about 10:45 p.m. It is further contended left HIL stop directly went near the school about 11:20 a.m. and having taken the children from the school. He left the school at 11:30 a.m. and passed through Point ITI gate, Ramnagara gate and Bangalore at 11:45 a.m. and he dropped the last children Devasandra at
So you're relying on only his evidence?
River evidence.
Only his evidence,
His
nothing
evidence.
else. Please come. The present appeal is filed, agreed with order passed in MBC number 120 for 2012 by the respondent PMTC. The case with the claimant is that the deceased had been to Bangalore to attend his avocation as flower decorator on 15/3/2012 at about 1:30 p.m. The sister of the deceased was in the house of his elder sister and she received a telephone call that her brother has met with an accident at Ramamurthy Nagar, Bangalore. On receiving such information, the petitioner, the claimant number 4, sister of the deceased, rushed to Ramamurthy Nagar, Bangalore and went to the accident spot where her brother was found lying dead. She inquired in the spot as to how the accident has occurred and which vehicle has caused the accident, resulting in the death of her brother. She was told by the public at the spot and other eyewitnesses to the accident that the Swaraj Mazda school bus belonged to the BMTC, bearing registration number KA01F2905, being driven by its driver in a rash and negligent manner in a high speed, dashed against the deceased. It is a case of the BMTC that the vehicle was not involved in the accident. In fact, at the relevant point of time, the vehicle was not plying in the said route. For this purpose, they have relied on the evidence of the driver, who has stated that at that particular time, he has not passed to the said road. The tribunal had given a finding that the court has observed that on perusing the copy of the charge sheet, the name of PW3, Harish does not find place as an eyewitness. The name of certain eyewitnesses have been mentioned in the charge sheet. In the statements given those eyewitnesses, namely Muhammad Ataullah, Rajesh Kumar Munirazu, have been produced as Exhibit P16 to P18, wherein they have categorically stated the involvement of BMTC bus number KA01F29055 in the said accident, and during recording of the statement before police, though as those eyewitnesses have stated that the driver of the bus was responsible in causing the accident. And the driver of the bus is also charge sheeted by the police. The prosecution launched against him is still pending trial. The driver of the bus has not challenged the charge sheet and never taken any steps seeking for quashing of the proceedings against the driver of the bus. Then the court has come to the conclusion that the bus is involved, and because of the rash and negligent driving of the driver of the bus, the accident had occurred, and granted the compensation of an amount of rupees 6,24,000. Next, the learned counsel for the petitioner, appellant BMTC submits that the court had failed to consider the evidence of the driver, which clinches the issue and also shows that the vehicle was not plying in the said route as on the date of the accident, and all these aspects were not considered by the court. And the court had, though the vehicle is not involved, still the liability is fastened on the owner and the insurer of the vehicle. Next paragraph. Having heard the counsels on either side, peruse the material on record. The admitted facts are that the police have filed the charge sheet. After a full-fledged investigation, has filed the charge sheet against the driver of the school bus. Except the self-serving or except the evidence of the driver, there is no other evidence placed on record to show that the said vehicle is not involved in the case. The considered opinion of the court had rightly believed had looked at the exhibits, that is charge sheet and other documents filed by the claimant, and rightly held that the accident has occurred because of the negligence of the driver of the vehicle, and the same is involved. That of the matter, this court finds no reasons to interfere. Accordingly dismissed. Next.
Till number 7, Satish T.
Amount in deposit shall be forthwith transferred to the trial court. Next.
Till number 7, Satish T. for appellant.
I appear for respondent number 2, my lords. Insurance company. Insurance company, ma'am.
No representation. List this matter for dismissal. Give a date. Cause for the respondent is present.
9/4.
Next.
Till number 10.
I appear for respondent, my lords. Insurance company.
Ravi
This is the
Shankar.
quantum of compensation.
Is there?
I'm sorry, my lord, the morning this is. It's a case of injury,
Accident of which year?
2010.
2010.
26/6/2010.
Age?
Age was 59 years at the time of accident.
Occupation?
That is, he was a teacher, drawing salary of rupees 30,374. Salary slip is produced as
30,000?
30,374.
When is the retirement?
But he is already retired.
No. Date of retirement?
62.
30,000.
He was accident.
30,374.
370. But surgeries have been done, and permanent disability of 20% to the lower limb, it has been taken as a 4% to the whole body. He was inpatient for 20 days in the hospital, and a surgery was done and fixed with the iron rod and screws. But the compensation is awarded at rupees.
Come to the table.
Please, no?
Table.
Table, your last 28. Page number 28, internal page 20. Pain and agony.
What are the injuries?
But the injuries, exhibit P7 is the, I'm sorry. Exhibit P7.
Not exhibit P7, from the,
Wound certificate.
no. It must have been recorded in the order.
Yes, it's not discussed there. But from the order.
Patient had suffered fracture of right femur, tibial plateau and lacerated wound for right leg. That is one fracture.
Yes.
40,000. Next, medical expenses, no dispute.
Yes, medical expenses, 1,31,000 is awarded. 51 medical bills have been produced. I think it is.
No, it says medical expenses, attendant and everything is coupled. What is exclusively medical expenses? Come to the discussion.
Medical expenses, special diet, attendant charges and.
No, that is correct. No, we will now bifurcate both.
Yes.
Where is
that has not been discussed yet.
No, it must be there. Where with regard to the medical bills, it will be discussed. Come to page number 23.
Let the petitioner has produced the medical bills and the prescriptions for 1,16,200. 200.
So 1,16,000. How many days you were in hospital?
Let 20 days. 20 days.
So we'll take 1,16,200 and another 20,000 for this.
Yes, ma'am. 1,60,000.
It comes to 1,36,000. Another 16,000.
Future happiness, unhappiness, and loss of
4% disability.
No. 20% to the lower limb.
Amenities 25,000 is reasonable.
Yes.
Loss of income during laid-up period
is 1,50,000.
It's a good amount.
Loss of vehicle also less is given. I have produced the
1,50,000. Future medical expenses
is awarded at rupees 15,000.
What did the doctor say?
Look, he has undergone the surgery and implanted with the iron rod and screw. In future,
Accident is of the year 2010. Will give another
Yes,
5,000, 20,000. Damages also is granted 15,000.
15,000 towards the vehicle, but the vehicle condition as per the photographs.
Whom you have examined in this regard?
Yes.
No one.
Doctor has been
No, for the vehicle.
Yes.
Author of the report is not examined, my lords, regarding the damages of the vehicle.
Yes, we'll take as it is. Any other thing?
Nothing.
It comes to 3,96,000. Agreed with award passed in MBC number 717 of 2010. Dated 6th December 2013. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 15 lakhs for the injuries
One
sustained by the
second.
claimant in the road traffic accident.
With your lordship's claim, may I take a leave. I'm sorry.
The court had, as far as the liability is concerned, there is no dispute. And the claimant is seeking enhancement of the compensation. As per the wound certificate, the claimant had sustained fracture of the right femur, tibial plateau, and lacerated wound of the right leg, lower leg, left eyebrow. According to him, he is working as a teacher and earning 30,374. And he was inpatient for 20 days. And accordingly, the court had granted compensation as per the table given below. When counsel appearing for the claimant submits that the amount of compensation that is granted by the court is on the lower side, and the same needs to be enhanced. Next para. When counsel appearing for the insurance company submits that the court had rightly granted the compensation and there are no grounds to interfere with the same. Next para. Having heard the counsels on either side, there is the material on record. Considering the one grievous injury at the head of pain and suffering, this court is granting an amount of rupees 40,000 towards medical expenses, 1,16,200 as per the evidence. Considering the fact that he is in hospital for 20 days, this court is granting transport and attendance charges at 20,000 towards amenities, loss of income during the later period, court and damages to the vehicle. Court had rightly granted the compensation and no interference is called for. Coming to the future medical expenses, considering that he has to undergo another operation, this court is granting 20,000. In the light of the law laid down in Make Law so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,96,200. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 3,71,000 to 3,96,200. The enhanced amount shall carry 6% into.
Bill number 11, DP for appellant, S.V.
Item
Prakash,
number?
11.
Yes.
List 1, 11.
Yes. You are on what ground? It's a case of death or injury,
Injury case.
and insurance company is
This matter has already had some time. There is two sketches were prepared by the IO. Two sketches regarding negligence aspect. Exhibit
So-
P5 and P7.
both were marked by them.
Both were one. PW1 has marked the exhibit P5, my lord. We have summoned the IO. He has filed exhibit R5. That shows, my lord, it is right side of the vehicle. This shows my vehicle is left side. Exhibit which I am relying upon. That
And
shows
what is
that
the
side.
court master said that he is not the investigating officer.
Please.
Is it?
That,
Which para?
Please.
Let's read from para 26.
Please. There are 22 onwards. There are 22.
No,
It's
the
definite
relevant.
defense of the insurance. Para 20.
So the main finding is at this
Main
place.
pending para 26.
26.
Further, the Mahazar found that exhibit R7, which contradicts the exhibit P4, though the contents reveals that the accident occurred due to negligence on the driver of the canter. Mahazar is drawn separately. It is very clear that the police have drawn two Mahazars. Exhibit P4, the signature of the Panchas, the two witnesses, number 2 signature and the bracket mentioned in his name. But exhibit P4, the copy of the Mahazar does not reflect the same. So it is very much clear that the exhibit P4 is certainly different and original also not found place in any of the police records. Though the police have drawn two Mahazars and two sketches in spot, they have not disclosed why they have drawn two Mahazars and two sketches at the spot in the same time, the same accident. The PW3 in his evidence stated that when police have drawn second Mahazar, then they have not written the detail. Hence, once again, they have drawn the Mahazar and sketch Though RW3 is examined by insurance company, he has also not given explanation why two Mahazars and two sketches came into existence. Well, the IO only tell about that why two Mahazar has been wrong. The insurance company not say that. The why sketch is different on going to the contents of the Mahazar in detail in reflects that the respond number 1 driven the vehicle in rash and negligent manner and caused the accident for the proceedings.
Only
That's
ground?
all. Madam,
That's the only ground.
please.
Then come to the table. Interest?
Yeah.
Interest?
Interest 9%.
See how much is interest?
Interest 6% only. Madam.
6%. Come to the table now. Their appeal is also there.
Please. People, is that page number?
How many are the injuries? Grievous injuries?
Please, madam. Fracture of shaft of right fibula and fracture of right femur. Two fractures.
Two fractures, 60,000. Then how many days he was in hospital?
As inpatient, madam.
So nothing has been stated. We
Please.
will also take the 20,000 only. Medical expenses.
(10/7/2011) to 27/8/2011.
How many days?
Three occasions, my lord, he has 10/7/2011 to 27/8/2011.
17 days. 17 days.
Again, my lord, 24 to 27, again 3 days.
3 days.
Again
17 plus 3, 20.
Again, my lord, on OPD, he has taken treatment for 4 occasions for OPD, outpatient.
No, we cannot. So 20 reasonably granted. How much is the income taken?
Income, my lord, 72,000 per annum, my lord.
No. It says for the loss of income during the later period.
Page 38, para 38, my lord, 72,000.
Come on, the petition taken at 72,000 per annum.
6,000 per month.
6,000 per month. Which year is this?
The accident occurred on, my lord, 2012, my lord, 9/7/2012.
We'll take 7,000. What is this case? How much is
Their
earning?
contention is that, my lord, he was studying MTech. For earlier to he was joined MTech, he was earning 16,423 as he joined some industry.
16,000.
16,423, but they have not proved that, my lord. Therefore,
So 7,000 into
7 is the disability. 23% to the limb and 7% to the whole body.
disability is
7%.
7%
To the whole body. 23% to the left lower
20?
limb. 23% to the lower limb. 7% has been considered. He was aged about 26 years, not 17 multiplier.
Multiplier is 17.
17.
It comes to 99,960.
99,960.
Loss of amenities. Another 5,000.
Please.
What is this permanent? That is permanent physical disability. That is loss of future.
That is calculated loss of future means instead of that mentioning. Laid up to 24,000 awarded. If my lordship grant 7,000, 28,000.
It's coming to 4,23,960. From
65,680.
3,680. Yes. Agreed with award passed in MBC number 241 of 2012. Dated. Only look at whenever claimant's appeal is there in the order sheet whether there is any delay or not. Even if I don't ask.
Yes.
Last objection.
Agreed with orders passed in MBC number 241 of 2012, dated 26 March 2015. The insurance company and the claimants, both the insurance company has filed MFA number 3938 of 2015, and the claimant has filed cross objections, that is MFA crop 76 of 2015, seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees. The claim petition is filed seeking compensation.
41 lakhs 40.
Huh?
41 lakhs 40,000.
41,40,000 for the injuries sustained by the claimant in the road traffic accident. It is a case of the claimant that on 9/7/2011, the claimant has been to Rane Benur in connection with his personal work, and he was returning towards Nelavagilu village in his own Bajaj Pulsar motorcycle, slowly on the left side of the road. By observing all traffic formalities, while the petitioner was moving near the mission house of Vegur Malleshappa on Shikaripura Masuru Road, near Mattipote Cross at about 5:30 p.m. The first respondent drove the Swaraj Mazda truck in a rash and negligent manner at high speed from opposite direction in wrong side and dashed to the claimant and caused the incident. In the accident, he had sustained 2 grievous injuries, and as per the evidence of the doctor, he had sustained 23% disability to the limb and 7% to the whole body. When it comes to the negligence and the involvement of the negligence of the driver of the vehicle is concerned, it is a case of the respondent insurance company that the IO has drawn 2 sketches. One is exhibit R7, the other is exhibit P4. In exhibit P4, your vehicle is on the left side.
P4, my vehicle is gone right side.
Exhibit P4, the vehicle of the offending vehicle is on the right side, and exhibit R7, that is on the left side. And basing on those 2 documents, they have denied the negligence on the part of the driver of the offending vehicle. But the court had considered the evidence of the IO and the 2 sketches, that is exhibit R7 and exhibit R4. The court observes that though RW3 is examined by the insurance company, you also not given any explanation why 2 mahajars and 2 sketches came into existence, but the contents of 2 mahajars are one and the same. Why sketch is different? On going through the contents of the mahajar in detail, it reflects that the respondent number 1 driven the vehicle in a rash and negligent manner and caused the accident, and further proceeded and turned turtle, and accordingly the court had held that the accident has happened because of the rash and negligent driving of the driver of the offending vehicle, and held that as the same is insured with the insurance company is liable to pay the compensation. Then coming to the compensation, the court, considering the injuries and taking the salary at how much?
My lord, 6,000, my lord, they have taken, my lord, he is he pursuing MTech, my lord, at the time of accident. 6,000, my lord, taken by the tribunal.
So we have taken 7,000.
My lord, that is a meager, my lord, as per, my lord, pursuing degree, who has pursuing degree, my lord, 15,000 taken by
these in cases of death. So what are you doing is what is important.
My lord, at least 10,000 maybe.
What did you say? The court had taken 6,000 and granted the compensation of an amount of rupees 3,65,680 as per the table given below at page number 32. The insurance company is questioning the liability and the negligence, and the claimant is seeking enhancement of the compensation. This court had perused the order of the trial court, having heard the counsels on either side. The trial court had rightly considered exhibit R7 and exhibit P4, and also both discloses that there is a rash and negligent driving. Just because two sketches are drawn, basing on that, the insurance company cannot contend that the vehicle is not, there is no negligence on the part of the driver. In fact, the said driver is charge sheeted. In those circumstances, this court do not find any grounds to interfere on the aspect of liability and negligence, and the court had rightly held that because of the rash and negligent driving of the driver of the offending vehicle, the accident has taken place. Then coming to the appeal of the claimant, cross objections of the claim, cross appeal of the claimant seeking the enhancement of the compensation, considering the two injuries sustained by him and the head of pain and suffering, this court is granting 60,000. For 20 days of hospitalization, court had granted 20,000 towards conveyance, attendant and nourishment, and no grounds are there to interfere with the same. Coming to the medical expenses, court had rightly granted.
My lord, for 48 days inpatient, my lord.
No, it is 20 days, he's saying.
No, 48 days, my lord.
Where from you get it? The remaining is as an outpatient. Inpatient is 20, that's what he read.
48 days, my lord.
This is OPD on 13/10/2011, 12/1/2011.
Admitted to inpatient 10/7/2011 till 27/8/2011.
How many days?
My lord, 28 days. Thereafter further underwent my lord, 13/7/2000, 16/7/2009 and 24/7/2011. Underwent skin grafting, and your lordship kindly come to
No,
para 3.
how many are the days?
My lord, he was discharged on 27/8 and further totally my lord 48 days, my lord.
10/7/2011.
Total on different dates, my lord.
No. As an outpatient, that we will not calculate.
My lord,
Only
inpatient
inpatient.
also. My lord, para 3, your lordship.
Para 3 of what?
Judgment.
Para 3 is your contention, might know what has come in the judgment. Which para you were reading?
Para 32.
30, please read para 30.
Not first, 10/7/2011 to 27/8/2011.
10/7/2011 to 27/8.
Please.
There itself, how many days?
My lord, on 24th.
So that itself there are about
20, 27, 47 days.
here only it's 47.
47
days, my lord.
Then remaining or OPD.
OPD.
So then we'll grant 50. If it is 50, then from 30,000 will increase. That is 4,53,960. What did you write? He was inpatient for a period of 49 days. This court is granting an amount of rupees 50,000 to his conveyance, attendant and nourishment. Medical expenses, court basing on the evidence had granted 1,86,000. There are no grounds to interfere with. Coming to the loss of earning, done counsel submits that he did his MTech, and according to him, is earning 16,000. The court ought to have taken the said amount, and it is submitted that in some of the cases, in several cases, the court had taken 15,000 in case of a MTech graduate. It is in this case, when it is a case of the claimant that is earning, he has to place before the court the evidence in that regard. If the evidence is not placed, then the court has to take the notional income. And this court is taking 7,000 into 4, 28,000 towards loss of earning during the later period. Then coming to the loss of future earning, 7,000 into 12 into 17, and the disability as per the doctor's 7% would come to 99,960. Loss of amenities, court had likely granted, the loss of amenities, this court is granting 20,000. Legal expenses in the light of so and so 10,000. Altogether, the claimant is entitled for an amount of rupees 4,53,960. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from the cross objections are allowed by enhancing the compensation from 3,65,680 to 4,53,960. The appeal of the insurance company is dismissed. The amount in deposit shall be forthwith transferred to the trial.
Loss of amenities and also
Loss of amenities for a disability of 7%, even in case of 20% also, court is granting 30,000. Lower court granted 15, I made it 20. Because there should be a uniform application.
Obligation.
Yes. Huh? Partly allowed, appeal of the claimant.
Amount in deposit make.
Cross objection, partly allowed.
List passed over matters in list number 2.
My lord, serial number 12 first list, my lord, actually I am waiting. It is passed over.
It's not passed over, it is adjourned. Adjourned or passed over?
No, it is adjourned. Delay condoned that it is listed on.
Yes. There is no delay in 12.
No. This is for final hearing.
It's coming up for admission 12.
It is on 16/4 for dismissal, no representation today.
16/4. Yes.
List number 2, passed over matters, serial number 6. P. Siddharamaiah for petitioner.
Appearing for petition. That is claimant's revision petition. That this revision petition is filed for limited purpose.
What is revision?
That this honorable court has reduced the compensation from 6 lakh and that to 4 lakh or 32.
You're seeking review of the order.
Review for this reason, my lord. The injured was in continuous treatment. He has died in consequence of the injuries.
When is the order passed?
My lord, order was passed. There is a delay, my lord. I'll accept, my lord. These
When
are
is the order passed?
My lord, order was passed on 8/8/2011.
8/8/2011.
2011.
When is the review filed?
Review was filed on 4/4/2000. Sorry, 15/2/2021.
15/4?
15/2/2021.
Can it be reviewed?
My lord, the reason is these two petitions are minor, and this injured has died in consequence of the injuries. We seek an opportunity to prove that he has died in consequence of the injuries. Long-standing hospitalization.
Legal proceedings of 2011 which were concluded on whatsoever reason, how can it be
condition
opened in
is, my lord, they
2020?
have spent huge money for treatment. Those facts were not pleaded in this petition, in this
That's
appeal.
what I'm saying.
Yes, I
How can the court review that order of 2011 in 22?
For limited purpose to prove, my lord, he has died in consequence of the accident. That is the reason we have filed this review.
That can't be done. Can't be done.
Normally we will not file, my lord, but it is a pathetic condition, my lord. Entire family has suffered.
No, for
a lot.
example, if an order is passed now and after 10-15
Medical
years, you
records are
want it-
available, my lord. We have the medical records, certified copies of the medical records. So leave it to honorable.
Please come. The present petition is filed seeking a review of the order dated 8th August 2011, whereby the court had
Reduce the compensation.
is reduced by 2,84,200, and it is held that the claimant is entitled for an amount of rupees. The court has partly allowed the appeal of the insurance company and reduced the compensation by 2,84,000 and held that the claimant is entitled for rupees 3,42,800 with interest as against rupees 6,27,000 as awarded by the tribunal. Now seeking review of the said order, the present petition is filed. It is stated that where are the grounds?
My lord, grounds is such a para number 10, my lord.
The review is filed on the ground that
The injured C. Nagaraja has sustained communication.
the late Nagaraja has filed the claim petition before the MSCT for the injuries of comminuted fracture of both bones of right leg and comminuted fracture of right elbow suffered by him in the accident. The period of treatment taken with the deceased is more, and he has incurred huge financial loss and also suffered pain. By considering the injuries, PW4 doctor has assessed the disability as 65% to the particular limb. The doctor has not properly given disability for comminuted fracture of 3 bones. The disability is still more than assessed by the doctor. Hence, the tribunal has considered the disability at 50% to whole body. And this court had taken the disability at 20% to the whole body. The physical appearance of the petitioner shows that the injuries are severe, and hence it has to be referred to the medical board. You are saying that he is no more.
Subsequently, he died.
Then why he should be? Then who has to be referred to the medical board?
Now it is not possible. My lord, para number 12, my lord.
Struck that entire ground. It is stated that the amount granted by
He should have been referred to medical ground. That should be the construction, my lord.
the amount
There is some
awarded by
grammatical
the
error
court
in
is
this.
very less, and the same needs modification of the judgment of the court. The third and fourth petitions were born on 12/9/2000. Now they have attained the majority. On verification, they came to know that the fact of the death of the injured in consequence of the injuries has not placed on record. Even the fact of continuous bedridden has also not placed on record. Since the injured was bedridden and the first petitioner, having lost all the source of income, is not able to prosecute the case properly, and in view of the same, rights of the minors have been affected due to lack of communication instruction. The fact of gangrene suffered by the injured was not being placed. Hence, what is this dismissal of RP?
Well, RP is allowed.
What are all these facts? First of all, you are coming to a court on a ground which is not available to you. And
Another ground is there is a wrong construction of the sentence. The ground is you should have been referred to medical board.
No, 12. You say RP number 27 of 2012 is not a bar to entertain present review petition. So already one review petition is filed.
Earlier review petition was filed. It was dismissed, my lord, without considering it. Under the facts and circumstances of the continuous injuries and after his
Is
death,
it not an abuse of process of law?
my lord, it is not suppressed, my lord. Earlier petition has also been.
First of all, once a review petition is dismissed.
My lord, at the time of injuries, earlier petition was filed. Review petition was filed. Since he died in consequence of the injuries, this review petition is filed by the minors to for an opportunity to prove that the death is consequence of the injuries. So they have suffered a lot, my lord. Yes, continuous
Earlier,
treatment. Yes.
questioning the very same order. Earlier review petition is filed. And at least they should be properly advised that these kind of petitions cannot be filed.
Conditions
cannot be
are
entertained.
pathetic, my lord.
Even however pathetic, we're all governed by certain
So
certain
these facts
procedure.
were not properly argued over.
Those are not the grounds. Those are not the grounds for a review. That earlier RP number 27 of 2012 is dismissed. In spite of that, the present petition can be entertained. This court has heard and considered the petition and perused the grounds. None of the grounds raised by the petitioner or the grounds for the grounds for reviewing an order that is passed in the year 2011. Hence dismissed.
Cell number 11. Issue serial number 11.
Sorry, my lord. Morning, I was not present, my lord.
List 2.
Serial number 11.
Sorry, my lord. Morning, I was not able to come to court. My colleague was here. On the last occasion, your lordship had asked me whether the MSA is pending, my lord.
Whether?
MSA was pending before the court below, my lord, the original court.
It is posted for final hearing. It is posted for final argument.
Hearing on 4th, my lord.
Will not entertain this MSA.
Then your lordship, only one ground. What the thing is, respondent number 13th is no more, my lord. He is the purchaser and who had filed the application before the court below. Your lordship could only observe that let them not further alienate or status quo to be
Why
maintained.
would we grant you? Why you can't be made a better in a better position than what you were in 2018? Please come. This is an MSA.
It only disposed of within that terms. Parties to maintain status quo, I would let,
Nothing will be said. Only the disposal you're saying that can be done.
please, ma'am.
Which is, where is that?
11 minutes.
11 and 11.1. The,
May I place this
I'll record that.
certified copy which your lord had?
The agreed with the orders passed in, agreed with the judgment passed in area number 57 and 72 of 2013, MSA 119 of 2018 and MSA 120 of 2018 is filed. By way of order impugned, the appellate court had set aside the judgment and decree passed by the trial court and remanded the matter to the trial court for fresh disposal in accordance with law after giving opportunity to both the parties to adduce their evidence. The aggrieved by the said remand, the present, these two MSAs or second appeals, miscellaneous second appeals are filed before this court by the, you're the appellant, defendant or?
No, I am the plaintiff, my lord.
Appellant plaintiff.
Appellant plaintiff before both the.
Appellant plaintiff. The order in RA number 57 and 72 was filed on 14th June 2018. When this matter came up on the last occasion, as there's no stays granted by this court wanted to know what is the stage of the proceeding before the trial court. Now it is brought to the notice of the court that now the matter is posted for the final arguments. At this stage, this court is not inclined to go into the merits of the matter. As such, this court, as these two appeals are dismissed, the order passed by this court is of the appellate court is of the year 2018. The trial court shall expeditiously dispose of the matter.
Within time frame of 6 months, ma'am. Within time frame, ma'am.
Expeditiously.
Please.
Yes.
Cell number 15.
I prefer the appellants, my lord, in this matter. Bunch of IAs, my lord, that I have filed to bring on record, my lord, the legal heirs of various deceased parties, my lords. I'll go by the cause list, my lords. Please. My lords,
I have 5 of 25 to condone the delay of 140 days in filing.
please, my lords. My lords, the delay here, I need to bring this attention to this honorable court, my lords. The delay is also because I'd filed an application previously, my lord. The coordinate bench found that application to be defective and dismissed it. That's why I have to file a fresh application once again, my lord. This is as regards
25 for condonation of 140 days application. What is the 6 of 25?
My lord, 6 of 25. My lord, 5 of 25 is for setting aside for application and file delay in filing the setting aside application, my lords. 6 is for filing the to bring the LRs on record, my lords. Both relate to the same appellant, my lords. 2 different reliefs. That's why there are 2 IAs.
That's what I'm saying. Which is the appellant?
Appellant number 7, my lords.
In respect of IA number 5, who is the appellant?
Appellant number 7. Just one moment.
7A to B. 7A and B.
Appellant number 7, my lords. Deceased appellant number 7. 2 LRs, my lords.
IA number 6 is in respect of?
Same appellant.
Notice is not gone. Notice.
No, what is 5, 6 and 2 are in respect of appellants number 7.
Please, my lords. One, my lords, is for delay.
No, that I understand. That is 5, 6 and 2 are in
Please.
respect of appellant number 7.
That's right, my lords. Please.
No, that next IA number 7 of 25 bringing the LRs to the deceased on record as A7.
Please.
There are 4 applications. No, there is something, there is one application must not be in respect of A7.
One must be for appellant number 8, my lords. Then.
That's what I'm asking you.
I'm sorry, my lords. I don't have the.
IA number 5 of 25 is in respect of appellant number 7.
Please, my lords.
Then IA number 6 of 25 must be in respect of appellant number.
I am just.
Then IA number 2 of 25 must be in respect of A9.
A8, my lords. A9 is still alive.
I'll call the next matter.
Please.
Please set these
I
facts
will.
clear.
I'll just check the court
Yes.
file. It might be permitted to.
Give
my
the
lords.
file to me.
I'm grateful, my lords.
Yes.
17. Cell number 17.
I appear for.
Yes.
Lords. 6 appeals in total, my lords. In one-
So, in 17 is concerned, it's coming up tomorrow.
Please, my lords, in 183,
Oh, MSA 183.
I have
For
given-
filing the amended cost title, it is adjourned to tomorrow.
please, my lords.
So in 17.1, 1 to 17.5, IA number 3, in all matters 3.
No.
Please.
Different.
IA
My
number
lords, 3 minutes.
3 of 24 is filed to implead the beneficiary as proposed respondent number 2. Mr. B.R. Prashant takes notice on behalf of the proposed respondent, and he submits that he has no objection to allow this application. Accordingly, I number 3 is allowed. Grant leave is to, what is leave?
For the LRs, my lords.
For the LRs?
My lord,
What LRs?
my lord, in 172, MSA
So
170.
accordingly, all IA number in all these
Impleading.
cases that impleading petitions are ordered, and he has to file the amended cost title.
Please.
This also you will do it tomorrow.
Please, I shall.
No,
do
no, all this will have it on Tuesday by the day you do it.
Please, much.
Uh,
Please.
All the matters on Tuesday for filing the amended cost title. Then what is this IA number 2?
My lord, IA number 2 to permission to bring the LRs on record, my lord.
What is this grant leave? What is that petition?
My lord, what would have happened, my lord, there, he would have not dead. While the disposal of the case in reference court or appeal, the appellant would
Generally,
have
the procedure is will file a LR petition.
but now after filing this appeal, he would have,
Then also, you say that so-and-so has died, so these are all the LRs, and accordingly, they may be brought on record as LRs.
My lord, this present LRs are the appellants have died after the disposal of the first appeal, my lord. This is a permission to proceed.
before filing the appeal, he is deceased, my lord.
Oh,
So
even
we
before
cannot
filing
file.
the appeal.
Please,
Before
ma'am.
filing the.
Then how come other applications can be allowed without that? In first matter, it is not there.
No, no, no.
In the remaining
the appellant
matters.
himself.
Yes.
Your Lordship, AJ accepts notice in this 7.1 to
In
7.5.
all the matters, AGA accepts notice on behalf of first respondent.
First respondent.
Yes. Give that IA,
IA number 2. 2 of 4.
and you filed all the death certificates
Please, my
and
lord, I have done.
let's see, give each one, 17.2, let's see,
17.2.
MSA 174. First of all, this application, then and see.
MSA 172, my lords.
Other for impleading. Impleading. 3 of course, that's also impleading.
172.
Especially impleading. Impleading the respondents. Grant leave. Grant leave. ಇದು ಎರಡರಲ್ಲಿ ಒಂದು ಎರಡು.
Where is your, where is the death certificate?
Lord, in 172, my lord.
Uttama, 10/12/2018.
174, my lords.
Place of,
Lord, it's in the page, in page number 80, my lords.
yes.
Just after the affidavit of the IA, my lords.
What is there at 81?
Sorry, my lords.
What is there at 81?
81 ಏನಿದೆ? 81 ಇದು ಪಡಿತರ ಚೀಟಿ. It's a ration card, ration card. ವಂಶವೃಕ್ಷದ, my lord, it's a G tree, my lords.
And this,
ವಂಶವೃಕ್ಷದ
yes.
G tree. Ration card.
Where is the death certificate I have seen?
Yes, my lords.
Where are like, she survived by whom? What is the evidence to that effect?
My lords, with respect to that, the ration card G tree I have produced.
Where is that?
My lord, it's in 81, my lords.
What is that? What it shows?
Genealogical tree, my lord. I mean, with respect to the ration card, my lord. Who are the family and the, what is the relation to that?
Look at it.
Page 81.
This is a family tree.
Family tree, your lordship. Issued by the Tahsildar.
Vamshavruksha, that is called a family tree. ಎಲ್ಲರೂ ಬಂದಿಲ್ಲ.
How many sons, how many daughters? List all these matters tomorrow. Please come up with a detailed.
Please, my lord.
Just like that, we can't grant leave.
Please, my lords. I shall do.
Let it come tomorrow.
Please, my lords.
No. Don't allow that. Unless and until leave is granted, question of allowing it will not arise. Yes.
Please.
Much obliged.
This is matter tomorrow.
Number 3.
Not tomorrow. List it on Tuesday.
Tuesday.
Yes.
List number 3. Passed over matters. Serial number 2.
That's for appellant minutes.
Can respond, please.
We have filed this application for enhancement, my lords. The accident has been happened on 13/12/2011, my lords.
15/12?
13/12/2011.
13/12/2011.
And he was inpatient from 13/11/2011 to 13/1/2012, my lords.
How many days?
And for follow-up
days?
treatment.
How many days?
It's around 1 month, my lords. Complete 1 month.
1 month.
Yes,
Month ಅಂತ ಹೇಳ್ತಾರೆ, but the judgment ಅಲ್ಲಿ ಸಾಬ್ರೆ discuss, they have not discussed any 1 month the judgment.
but
30 days.
yes. And the follow-up treatment till 2015, my lords.
Then what is his income?
Income is 6,000, my lords, as of 6,000 wages plus 100 rupees bata, my lords. But they have considered only 3,000
So how much in a month? 6,000?
plus 100, my lords. 6,100.
That is 3,000, that is 9,000. 6,100 rupees.
Yes, my lords.
Is your
Per day,
income.
per day 100 rupees, my lords.
So then it will amount to how many per month?
9,000.
It comes to 9,000 in Nivala Prakara.
9,000. And in wound certificate, my lords, it has been taken as
1 minute, any disability?
yes, my lords, right leg.
What is the doctor's evidence?
My lords, his right fibia and tibia fracture, my lords, and injured, and he has been done with IMIL nailing, my lord, to his right leg.
If you are not able, if you have not gone through the facts, we'll
No, my
have it
lords,
some other
I've
day.
been through the fracture.
Then what is the percentage of disability?
20 to
according-
26%, my lords. 20 to 26.
22 to 26% disability to the limb.
Yes, my lords.
To the whole body, how much he said?
9% taken.
9% they have taken, my lords.
Please come to the table.
Yes, my lords.
Judgment number 12, please, madam.
Now, how many are the fractures, Mr. Benny?
Lords, one fracture, but they have operated the leg, my lords. It's
One
cost.
fracture,
Yes,
40,000 towards pain and suffering. Next.
No, but
law.
this is ECA, please, madam.
Huh?
This is ECA, not MSc.
Oh, ECA.
Yes, ma'am.
In ECA, pain and suffering has.
Adu
different
Baragila,
meaning.
it is not applicable, please.
And the court has granted 20,000.
Granted, please. We
You
are
are
not in appeal.
Yes.
But the
You are
accident
not in
happened
appeal.
during the course of employment only, it has happened.
Loss of income during laid up period. As per the notification, what is the amount?
It's around 16,000, my lords.
Huh?
Trial court has
As per the notification, what is the minimum wage as on the date of accident?
it was 6,000 only, my lords.
My submission, kindly turn the para 20 of the judgment, please. It is the owner deposit that he is paying the 3,000 rupees per month, 50 rupees per bata every day. It is admitted by the owner of the vehicle.
But there
The
was
same
no,
is considered by
there was
the
no
learned
proof, my
judge.
lords.
Huh?
But there was no proof regarding that, my lords. Because for wages, there will be no proof.
As per the notification, what are the minimum wages as on that day?
Hello, but
But they have considered only 60% of wages, my lords.
that is to be taken. Owner said that he is paying monthly 3,000 rupees, 50 rupees per bata, 50 rupees per day bata. It comes to 4,500. The same is taken by the learned judge. It is not a case for enhancement, please. Even bata is not an income. It is only for daily purpose, please.
My lords, with he's a cleaner, my lords. And he used to work as well as for lifting and other shifting goods also, my lords.
This is matter on 17th of April as part. Yes, next.
Serial number 4. N. Krishnaswamy for appellant. Serial number 4. Kundika Ishwara Bhatt for respondent.
Represented and dismissal.
Respondent in this case, madam. The connected case.
Yes.
Head of collision. This case, my lord, challenging
for the claimants.
Yes.
Challenging the negligence, my lordship.
You are
The
questioning the?
negligence, the deceased who was riding the motorcycle, who came on wrong side and dashed against the bus, my lord. The police, after thorough investigation, have filed a charge sheet against the deceased, my lord.
Oh.
He himself is negligent in causing the accident. Earlier, he was filed a claim petition under section, my lord, 166. Afterwards, he has converted to 163A.
Not he. He is no more. That person who met with an accident is no more.
Death case only.
ಅದೇ ಡೆತ್ ಅವರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟದಲ್ಲ ಅಂತ ಹೇಳಿದ್ ನಾನು.
Complaint ಹೇಳಿಲ್ಲ ನಾನು. I am not stated anything about complaint. I am telling about the charge sheet. It is filed against the deceased. Earlier, my lord, the claim petition, my lord, initially filed 166, claiming compensation of rupees 7,50,000.
163A then converted into
You can
166.
say, like, we'll also hear you. Yes.
My lordship, judgment, my lordship, page 2 of the judgment may kindly be seen. judgment.
Yes.
The petition filed under section petitioners at the initial stage under section 166 for rupees 7,50,000. Subsequently got amended the claiming under section 163 of MA Act.
So this is an application of 163A.
Please, ma'am.
Yes.
The MSCT, my lord, coming to the conclusion that it has treated as 166 again, my lord, and taken the income
6,500.
6,500. 6,500 rupees. The paras
Application is filed under 163A. Why could have taken
converted again 166, the MSCT has considered. 50% negligence has fixed against me, my lord, and 50% against the deceased.
166. Please come to the findings.
Please, my lord.
Come to para number 7.
Para 15.
Yes.
At this juncture, I would like to consider the decision referred by the learned counsel for the petitioner contesting the respondents pertaining to the section 163 of MA Act. But there is a misconception of real state of the affair of the wrongs case made out by the petitioner through the counsel and getting the petition amended by considering the provision of section 163A and income at 3,300 per month. And the rest of the contents of the petition kept it as it is. Hence, we were in view of the earlier case for it withdraw the with liberty to file a fresh. This petition should be considered. It has filed under section 166 of MA Act only. Therefore, the decision referred them are distinguished hereinafter. 2001, the judgments has been referred. My lord. The MSCT itself, my lord, the income they are restricted to 3,300. Earlier, my lord, they stated he was working in a fireman in MRPL, Mangalore, and earning 7,667 per month. He is restricted to 3,300 while amending the claim petition. Therefore, MSCT on his own reasons, my lord, coming to the conclusion that again directed to
Decided the case on
decide the case
166.
If that is so, my lord, the charge sheet filed against him only, my lord, deceased, my lord. The claim petition itself is not sustainable, my lord, because self-accident. And he himself is a negligence, my lord, he cannot claim compensation against the other offending vehicle.
That's why they are filed under 163A. Court has done all
But
this.
it is converted to 166, my lord. And given a finding that and awarded, my lord, 8,11,000. Out of that, my lord, 50% contributory negligence has fixed against the insurer of the offending vehicle.
What do you say?
Lord, the finding given by the tribunal is just and proper. It is a claim petition under 166, and according the income which I have produced the document to the effect that he was drawing a salary of 7,000 and odd is clear from the document exhibit P11. Therefore, my claim petition under 166, where the finding given by the tribunal is just and proper. It does not call for interference. Then I have challenged so far the fastening of the liability to the extent of 50% on the rider of the motor vehicle deceased. The accident was taken on the middle of the road, and the opposite vehicle, it was a bus. If had he taken little care, he could have avoided the accident. The spot measure is very clear. That is exhibit P13. It clearly shows that the accident was taken place on the middle of the road. He was coming from the opposite side, from south to north, where the bike was coming from the north to south. And accident was taken on the middle of the road, as could be seen from the measure, and the spot sketch was produced before the tribunal.
No, the charge sheet is filed against the deceased. What is the evidence adduced by you before the court to show that it is not the negligence of the deceased, but it is the negligence of the opposite vehicle?
That is the claimant's evidence. I have not examined any other witnesses. Claimants have, before the court, they have stated that it is not, he is not negligent.
You are appearing for whom?
Claimants,
That's what I'm
mother
saying.
and
What is the evidence adduced by the claimants when it is a petition under 166? You have to prove the negligence.
Please.
And when the medical and the police records are contrary, saying that the deceased was negligent. In that case, unless and until there is an evidence.
Only the charge sheet was filed against the deceased because immediately after the accident, as could be seen, he is not the deceased. He was taken to the hospital to the some third party. Then he was declared dead. Therefore, based on the complaint, it can't be decided that he was negligent.
Then we have to, then there should be some other evidence. That's a burden of the, if it is 166, burden of the claimant. If it is 163A, then the consideration would be otherwise. And rightly, the advocate has advised to file a petition under 163A. Court unnecessarily messed it up and turned it into 166. Advocate advice was correct. Now, once if it is treated under 163A, what would be the table? Compensation?
163A, my lord.
My lord, if 163 is there, his appeal is not maintainable.
Because he has stated that his income is 7 lakh.
Income 7,000.
I think he is appearing for whom I don't know. Swami. Then why you are arguing against me? That is my, though he is appearing for insurance, why he is arguing against me?
They belong to the insurance fraternity.
It is not fair. He should not. In the present case, he can't raise that such objection. It is not fair.
In the light of the Supreme Court judgment, once you say that your income is 40,000 or what it is?
40,000
per annum, then question of restricting the claim to lesser amount will also not arise, and you cannot maintain a petition under 163A also. Girish Bhai Soni, what is the judgment?
Deepal by Girish.
Deepa, 2004 Supreme Court.
This is matter on Wednesday as part heard.
2. Cell number 5. Renuka for appellant.
Sorry, my lord, I was not present in the point.
Yes.
My lord, my case is on the application which I filed, my lord, under order 41 rule 27, seeking additional evidence on the ground that, my lord, there is suppression of facts as regard to the implication of the vehicle. The bus was not involved in the accident, my lord.
What is the document that?
My lord, the extract of the MLC register of the hospital of the first instance, because he was admitted to government hospital.
Objections to that?
No, my lord.
When is it filed? 2014?
Yes, my lord. My lord, the author of the document, they have not been examined, my lord. They've just produced the document, my lord. And in FIR charge sheet everywhere, it has only been given as private bus, my lord. So.
No, let us look into.
Yes, my lord.
Please come to the finding of the court with regard to the accident.
Well, at page 12, that is judgment page 6, in page 12, exhibit P1 shows that the Bangarpet police have registered a crime against the driver of the KSRTC bus bearing registration number so and so. On the basis of the complaint filed by one Govindappa, the police have charge sheeted against the driver of the bus for the offences punishable under section so and so. Though the respondent number 1 driver had denied the accident, nothing significant has been elicited in the cross-examination of PW1 to displace the case of the petitioner. Except denial of respondent number 1 has not placed any material to falsify the fact of accident. Accordingly, the petitioner has proved the accident by placing oral and documentary evidence. This is important. The other contention of the petitioner is that the petitioner has sustained grievous injuries and has taken treatment in government hospital KGF. This is the hospital record which I have produced, my lord, now, which was held back by. Then to RL Janappa Hospital, Kolar, and contended that he has sustained grievous injuries. To substantiate the same, the petitioner has produced wound certificate, discharge summary, wound certificate of so-and-so shows that the petitioner has sustained 3 injuries and all the injuries are grievous in nature. Petitioner got examined, so-and-so, and further deposed that the doctor who treated him. PW.
What that says?
Well, I have produced along with the application, my lord. It's an extract of the MLC register, which says, my lord, that it is vehicle is hit by a private bus, my lord. History of RTA near Nilakere temple when a private bus had hit him as he was going on a cycle at about 7:30 a.m. He was taken to private hospital from where he came to this hospital. My lord, along with the application, my lord, I find that.
Looking at.
Specifically, my lord, private bus is mentioned, my lord, because ours is a government bus, my lord. It cannot be,
My lord, they've only,
because subsequently, my lord.
May I submit, my lord? They've only given us a private bus. Nowhere in the FIR charge sheet, the private bus number has been mentioned, my lord. If it was hit by an unknown number, unknown bus or any vehicle, that it would have been mentioned as hit by an unknown vehicle, my lord. But everywhere in the FIR charge sheet, KSRTC bus, clearly it has been mentioned, my lord, KA07F901, my lord. So clearly, it has been the accident has been done by the negligence, and even the driver also has, in cross-examination, he has told that the accident it has happened. It is true, and I've not reported the same to my higher authorities. He has agreed the same in the cross-examination, my lord. It has been
Who has taken him to the hospital?
his brother, my lord. His brother Govindappa has taken him to the hospital, my lord. So he has signed the case sheet, and he has just told he's been hit by a bus.
No, private bus. Sorry, it's private bus.
No, it's just a contention.
Bus, it is a bus.
Yes, my lord.
Please come. And what about, you have preferred any appeal?
No, my lord.
But they had preferred and it's rejected, my lord.
Oh, yours is not, this is fine. Please come. Agreed with the word passed in embassy number 8802 of 2010, dated 9 July 2012. The KSRTC is before this court. The KSRTC has also filed an application under Order 41, Rule 27, placing before this court the MLC register extract of the government hospital.
Yes, government hospital.
Of the extract of the medical register of the government hospital KG in which the claimant was admitted after the accident. Coming to the facts of the case, the claim petition is filed seeking compensation for an amount of rupees 30 lakhs for the injuries sustained by the claimant on 25/9/2010. It is a case of the claimant that on 25/9/2010, he, while walking from Dasara Hosahalli from Bangarpet at about 6:30 p.m. near Bangarpet KGF Road, a KSRTC bus driven by its driver in a rash and negligent manner dashed to the claimant near Banganur Gate. Due to the accident, he had sustained grievous injuries and was taken to Kamadhenu Hospital, PK Halli, after first aid Government Hospital, KGF, and then to RL Jalappa Hospital, Kolar, and he was treated as an inpatient. It is a case of the insurance company that the KSRTC that the vehicle is not the vehicle is not involved in the accident. Before the court, the trial court had the trial court has given a finding that the claimant has the accident by placing oral and documentary evidence. The court observes that on the basis of the complaint filed by one Govindappa, the police have filed charge sheet against the driver of the bus for the offences under section 279, 337, 338 IPC Directives 134, AB 187 of the IMB Act. Exhibit P1, which is registered on what date? On the same date, shows that the Bangarpet police have registered a crime against the driver of the KSRTC bus. 27. The claim that is registered on 27/9, the 2 days after the incident, the number of the bus is also shown. Accordingly, the court held that the KSRTC bus is involved in the accident, and because of the negligence of the driver, the accident had taken place. The learned counsel appearing for the KSRTC had, basing on an application filed under Order 41 Rule 27, and the extract of the register, MLC register, submits that in that it is mentioned that he was hit by a private bus, and it is a submission that it is the submission that it is a KSRTC bus but not a private bus. As such, the said aspect was not brought to the notice of the court. As such, taking that into consideration, it has to be held that the KSRTC bus is not involved in the accident, and the bus has been implicated, and as such, the claimant is not entitled for any compensation. When counsel appearing for the respondent claimant submits that right from all the police records, the number of the vehicle is mentioned, and mentioned in the MLC register, because they have taken it as a written as a private bus, that does not mean that it cannot be said that the bus, that is a KSRTC bus, is not involved in the accident. It is submitted that on that ground, the order of the trial court cannot be interfered with. It is submitted that when they are relying on a particular document, the author of the said document, the persons connected with the said document, the hospital authorities have to be examined, and without examining them, any amount of evidence that is placed before the court is inconsequential. Next paragraph. Having got the counsels on either side, there is some material on record. Before the trial court, it was never the case of the insurance company. With regard, it was a case of the insurance company, a case of the KSRTC, that the vehicle is not involved. The court, considering the police records and other documents, had held that the vehicle is involved in the accident, and held that and fastened the liability on the KSRTC. And this court has perused the application filed under Order 41 Rule 27. The counsel for the KSRTC is relying on the said document to show that because it is stated private but not KSRTC, as such, it shows that the KSRTC bus is not involved. This court is not able to appreciate the said submission that the involvement of a bus is not in dispute. If as had this been filed before the trial court, and had the claimant would have had an opportunity at that point of time to examine the concern with regard to what has been stated. Now, after these many years, even by remanding the matter, no useful purpose would be set. Hence, basing on that, this court cannot interfere with the findings of the trial court in the light of other documents that are placed before the court. In that view of the matter, this court finds no reasons to interfere. Accordingly dismissed. Yes, next.
Amount in deposit.
Amount in deposit shall be
Much obliged.
forthwith transferred to the trial court.
Much
Number
obliged.
6, M. Anil Kumar for appellant, A. N. Krishnaswamy for respondent.
Respond.
Yes.
Case is dismissed against,
So on the ground that
on the ground that involvement of vehicle is
heard the learned counsel for the respondent insurance company in part, no representation for the appellant. Is this matter on second?
Four. Serial number 7,
Yes,
K. Shashikant Prasad, serial number 7.
this is also dismissed. Same on the day, heard in part, no representation for the appellant, heard the car,
2, 4.
then counsel for the insurance company. Yes, next.
Serial number 8, Patel D. Karegowda for appellant. A.N. Krishnaswamy.
Yes, Mr.
This appeal seeking enhancement of compensation.
You are on what ground? Krishnaswamy. You are on what ground?
Fall from motorcycle converted as a hit by motorcycle bearing another motorcycle. This is the, there is 5 days delay in lodging the complaint, number 1. MLC available at record would indicate that it is a fall from two-wheeler motorcycle.
Let's
And
see the
exhibit
finding of the
P7, my lord, most strange thing is a document that is produced by the claimant itself would indicate that it is fall from it.
Let's see what is the finding of
P7.
the court on that. Para number?
10. Number 10.
Please read.
And may I read my-
May-
on the other.
On the other hand, the respondents have denied the rash and negligent riding of the motorbike by its rider at the time of alleged accident. But in support of their contentions, they have not adduced or produced any evidence. Further, they have also not denied or disputed the police documents, nor they have taken any contention that the police have registered a false case against the rider of the motorcycle. Further, the charge sheet is filed only after complete investigation by a public officer while discharging his public duties, and hence it is a genuine document and can be believed. Even if the contention of the respondents is presumed to be true, the respondents ought to have explained as to why the motorbike was found at the alleged spot of accident and for what purpose it was seized under Exhibit P3 and subjected to IMB inspection. But there is no explanation in this regard. For these reasons, it is clear that the respondents have failed to disprove their contention. The respondent number 2 has taken up a specific contention that there is delay in filing the complaint. But a perusal of complaint exhibit P1 shows that it is lodged by one Harish, who is said to be the brother-in-law of the claimant and an eyewitness to the alleged accident. And the complainant has clearly stated that in the complaint that immediately after the accident, he had shifted the claimant to a private clinic at Nittur and thereafter shifted him to Wakard, Bangalore. And as there was no one to look after the complainant, he was busy in taking care of a claimant and hence he is lodging the complaint with a delay. This reason appears to be genuine and obvious when the respondents have not shown that there was any occasion for the complainant to lodge the complaint immediately after the accident. Hence, the delay in lodging the complaint is not fatal to the case of the claimant. Thus, this contention of respondent number 2 does not hold water.
How, according to you, you are walking on the side of the road and the motorcycle came and hit you. Then the MLC extract says that it's a fall from the bike. Are you not supposed to, examine or seek a clarification why it is entered in the MLC register like that? It's your case, you're walking.
Please.
Then the document is also filed on your behalf.
But in this regard, the insurer not laid any evidence.
Huh?
Not laid any evidence. Charge sheet is filed against you.
First of all, the evidence is on the burden is on you to prove that the accident has happened because of the rash and negligent driving of the driver of the vehicle. And your case is that you are walking on the side of the road and he came and hit you. And you have filed certain documents in support of your case,
Please.
which shows that yours is a fall from the bike. not you're hit by a bike.
Like a document. Like a-
Exhibit P4
P4.
is MLC extract.
This is a own certificate. madam.
Take that.
Exhibit P4.
Discharge summary 7.
MLC extract itself is not produced.
Then whatever it is, that is your document.
MLC extract not produced, madam. Only own certificate exhibit P4. If that document
You
is
not produced MLC extract.
Well, in order to prove.
Can you, it would be in the similar lines. How it is
In
there
order
in
to
this.
prove the case, Malad, in order to prove my case, Malad, I have produced, Malad, occurrence of accident is concerned, I have produced the police records.
So where do you get exhibit 4 says alleged RTA, where it says fall from the bike.
R7.
Exhibit P4.
R7.
P4.
I'm sorry, P7.
P4 says RTA.
Exhibit P7.
7 is?
Discharge summary. That means certificate.
Where do you get that?
One.
Not that, I guess. 5 days.
Fall from bike, chief complaint, fall from bike. It is on 9th September 2009.
Yes, ma'am.
This discharge summary is Wakad Hospital, Bangalore, Malad. Wakad Hospital, Bangalore. This is, Malad, immediately after the accident, the injured was taken to the Nittur Hospital, Nittur Clinic. Malad, that was the first MLC.
Where
record.
is that?
That is not produced, Malad. Thereafter, he was shifted to the Bangalore Hospital.
No, it's your, that's the burden is on you to produce all this.
Please,
And you produce something which goes against your case.
Well, date of admission, if I'm interpret this, admission
9th
in 9th September, 9th September, Malad.
When is the accident?
8/9 is the accident.
Then?
1 day later, he was shifted to Bangalore Hospital.
So 1 day later, it will not become fall from
Malad,
bike.
No, Malad, what my submission is, Malad, immediately, Malad, document is a Nittur Hospital, document is relevant document because, Malad, he was in position, not in a, Malad, position to, Malad, record all this.
What do you want to do?
If I will go through once again, I will make submission on next one date.
This also parted. Heard both the sides. List has parted on the same, on that day.
Please.
Number 9. 9. Gunashekar R for appellant. Girish B. Baldare.
Number 1.
Counsel for the respondent present, no representation for the appellant. This is matter for dismissal. Give a date.
8/4.
Next.
Cell number 11. Mushtaq Ahmad. Cell number 11.
Claimant's appeal for respondent number 2.
It is insurance company's appeal.
Claimant's appeal, my lord.
Claimant's appeal. You appear for the insurance company.
Respondent number 2, my lord, insurance company.
Huh.
Well, I have sought for enhancement of the
Which year is the accident?
2009, my lord.
2009. Occupation?
He was working in private factory. He has produced salary certificate for a sum of rupees 6,000 rupees. It was marked.
How much the court had taken?
5,000 taken. But future loss of income is not awarded, my lord.
What are the
The doctor has assessed 26% disability.
to the limb?
Yes,
Yeah, limbo.
not whole body. my lord.
Only whole body.
Whole body.
Limbo has not mentioned. Assessed disability. Limbo is not assessed
Court had
disability.
taken how much?
He has not taken.
Taken. Let's see.
Para 17 of the judgment. Madam.
Para?
17 of the judgment.
One Dr. Suresh has assessed the disability.
Ask what are the injuries?
Injury, my lord.
Simple injury.
One simple and one grievous injury, my lord.
First
Serious
one,
injury
simple.
is fracture?
Injury number one, simple, my lord.
Uh.
Injury number two is grievous.
Left tibia fracture.
injury.
Left
Left
tibia
tibia
fracture.
40,000. Then medical expenses as it is.
35,000.
35,000 is awarded. 35,518 awarded. Amenity awarded 10,000.
How many days he was in
1
hospital?
month, my lord.
Huh?
No,
1
he
month.
has not produced discharge summary, my lord. Not produced discharge summary.
Hmm.
And
Loss
amenity.
of earning during. Have you examined anybody in support of your income?
No, my lord. I have produced only salary certificate.
Which year is the accident? You said?
9, my lord. 2009.
What you have taken?
6,000, my lord.
5,000. 2009.
The
Court had taken?
court has taken 6,000 as per my salary certificate.
Then it is, as per the table, it is 5. So if the court has taken 6, let it be. 18,000 as it is, we'll let it. Next, coming to that, loss of future earning, please show that discussion at which para?
Para 17.
17 of the judgment.
Para 17. Please read that. Yes.
The petitioner has examined PW2 Dr. Suresh PA, the orthopedic surgeon, Government Hospital, Koratkere, who claimed to have given treatment to petitioner, and this witness has worked out his disability to whole body at 26%. And further, he has deposed that the petition is required 25,000 rupees for future medical expenses. This witness has cross-examined by the learned counsel for the respondent, wherein he deposed that the petitioner came to me for treatment in the month of December 2012. This is clearly reveals that the accident took place on 24/2/2009, and this patient is filed on 26/10/2009, and the witness examined.
The doctor's evidence is disbelieved.
Almost 3 years.
Yes, my lord, but he has treated as further treatment he has given, my lord.
2009, 2012.
Further treatment he has given, my lord, for non-united, my lord.
Where did he say
The
so?
injury,
They'll continue.
he has himself has deposed in his evidence, my lord. The evidence of the Dr. Malad. I submit that as per the wound certificate issued Government Hospital, Hindupur.
Now,
Yes.
for assessing the disability, he has to take that fresh X-rays and other
He has
things.
taken.
Where is the evidence? What did he say?
He has deposed that he submit that as per the wound certificate issued at the Government Hospital, Hindupur, he has simple injury of lacerated over left tibia over chain region 2 × 4 centimeter size and grievous injury to the left tibia fracture appeared. I came to know from the records that he has admitted in Balaji Nursing Home on 24/2/2009. He has treated there with mediation and underwent the tibia nailing screw and discharge. It was from the records. He took treatment and follow up the treatment. Recently examined on 14/3/2013, the Renuka Hospital, Korategere, by taking X-ray, he is diagnosed to be a case of left knee and left ankle stiffness with the malunited fracture tibia with nail with the C2, the mediation and physiotherapy. And he has the following complaints. He is having following complaints. He cannot bend the left ankle totally. He cannot do full movement of left ankle. He cannot run or walk upstairs properly. He cannot squat on ground or pass motion in pain in the left leg. As per the Almico and the special gazette of the government and so on, so on, so he is having complaints. Unable to do squatting on the ground, unable to knee on the ground, he cannot walk on upstairs. Cannot sit on the ground. He cannot stand on the leg, my lord. He is having a disability, my lord. He has treated, further he has given the treatment. My lord.
What treatment he has given? He is telling about what all happened to him earlier. That can't be considered. But he says that they're not united.
No, my lordship, almost after 3 years and during the pendency of the petition and assess the disability.
There's one more thing. If the situation remains to be the same, no, can't he assess the disability? Can't he assess the disability?
Assess the disability, limb is not mentioned, my lordship.
Limb is not?
Limb would not assess the disability is a particular limb, my lordship. Only whole body assess the disability. 26%.
We'll take 10%. 10%. He says it's malunited. Remanding the matter and doing all those things, it is.
Please, ma'am, remand the matter, ma'am. Examine the matter.
Again, you have
Matter to be remanded.
no, again I have to approach the doctor. Another fresh doctor we have to approach.
No, but why his evidence shall not be taken into consideration? That it would have an impact. The fracture is to which place? To the foot.
Yes, ma'am.
We'll take 10% to the whole body.
5%, my lordship, please.
What is the multiplier?
18.
18, my lord, 25 years old.
It comes to 1,83,318 from 79,518. Please come. Agreed with the order passed in MEC number 112 of 2009 dated 20th September 2013. The claimant is seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs of injuries sustained by the claimant. It is the case of the claimant that is working in a factory and earning an amount of rupees 6,000.
6,000.
6,000.
Yes, ma'am.
6,000 per month, and he has also filed the salary certificate. He has examined the doctor. Doctor says he had sustained 26% disability to the whole body. The court had disbelieved the disability, the evidence of the doctor, and granted the compensation as per the table given below at page number 16. When counsel appearing for the claimant submits that when the doctor had deposed that he has sustained 26% disability, court had not granted any amount. Even with the other heads also, the amount that was granted by the tribunal is on the lower side. Next para. When counsel appearing for the respondent insurance company submits that the court had rightly granted the compensation basing on the evidence available on record. And the court had rightly not considered the evidence of the doctor who had not treated him, who had treated him after 3 years, and admitted as on that day there are no new injuries. He submits that there are no grounds to interfere with the well-considered order passed by the court. Next part. Having heard the counsels on either side, produce the material on record. The first issue is with regard to the evidence of the doctor. The doctor had given the evidence that the disability, whole body disability is 26%. He has not assessed the limb disability. The doctor had spoken about the X-rays that were taken and that the malunion of the said the fracture. Without assessing what is the disability to the limb, the doctor had held that the disability to the whole body is 26%. The court ought to have considered the said evidence and ought to have assessed the disability reasonably, considering the condition and the fact that it is a malunited one. In view of the same, this court is inclined to take 5% as a disability under the head of loss of future earning. 6,000 into 12 into 18 into 5 by 100 is 64,800. As he has sustained one fracture under the head of pain and suffering, this court is granting 40,000. Medical expenses quoted rightly granted and no interference is called for. Towards transport, attendant and nourishment, this court is granting 15,000. Then coming to the loss of earning during the later period also,
Which are medical expenses?
quoted granted a reasonable amount and no enhancement is called for. In the light of the law laid down in so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of 1,83,318. Accordingly, the appeal is allowed, enhancing the compensation from 79,518 to 1,83,318. The enhanced amount shall carry 6%. Next.
12. Serial number 12, T.N. Vishwanath for
I'm for
Sorry,
respondent.
Raju.
In the other court in the morning.
Yes.
Lords, the first appeal, my lords, MFA 7660 of 2015 is arising out of.
You are representing Mr. P.B. Raj.
PB Raju, behalf of PB Raju, I am representing.
It is arising out of MVC 2458 of 2014, my lords.
313 days not entitled for interest. As per the order dated so and so. In every case, you see that. Yes.
The relevant paragraph is paragraph
No,
number
MFA
76
arises out of
2458 of 2014, my lords.
2458. Next is?
Next is 2457, my lords.
7661 of 2015. MFA.
I'll just take the wrapper, my lords. It's fallen. My notes is.
Look at it. Next. There are 2457, 2458. There is no other number.
No other number. Two numbers.
If it is 2458, the other is 2457.
MFA 7660.
The case of death or injury.
Injury.
Both are
cases
injury only,
injuries.
Rider and pillion
You're
rider.
on enhancement.
Please.
Now
Lord.
first coming to, let's see, MVC number 2458.
Lots.
Or we will see MVC 2457. What is the, come to the table of MVC 2457?
Please.
Page number?
Page number, judgment page number 17, my lords.
7?
17, judgment page number.
MVC 2457.
Please,
Please.
How many are the injuries?
Lots. In 2547, my lords, he has sustained lacerated wound over forehead, 3.
How many fractures?
My lords, 3 fractures, my lords. Fracture glenoid cavity right scapula, comminuted fracture right tibia, comminuted segmental fracture of right femur.
It's another 20,000 for pain and suffering.
Lots. In this, my lords, as per the doctor's evidence, my lords, there is shortening of right lower limb by 2 centimeters, my lords. And there is
that we will go to the next.
Please.
Now only on the pain and suffering.
Lots.
Then how many days he was in hospital?
Lots. He was an inpatient, my lords, for 13 days, my lords, on 2 different spells in Panacea Hospital.
We'll grant 13,000. Another 3,000 on that. Then loss of income during the later period. What is your income according to you?
My lords, as per his self-testimony, my lords, he was working as a marketing manager at Calcutta Tube Center and was earning rupees 27,000 per month. But tribunal, my lords, has taken
10,000 per month, my lords.
Why there is no evidence?
Please, my
Except
lords,
salary
that
certificate, they
has
have not
not been
produced.
proved.
Which year is the accident?
2014, my lords.
8,500 rupees, but they taken
Only
10,000.
taken, no enhancement on that.
My lords, since he was inpatient for about 13 days, my lords, 3 months they have calculated as the laid off period. May I request for another 1 or 2, because he had the follow-up treatments and he has undergone surgery. There is
Additional, my lords.
shortening.
We'll consider it as 4 months,
Please,
40,000.
additional 1 month.
Next, loss of income due to disability. What is the evidence of the doctor?
My lords, the doctor, my lords, has deposed that
Para number 30, my lords.
30?
30. Para number. Page number 15. Judgment page number.
Thus, from the overall assessment of the evidence of PW,
60.6%. Then whole body would be around 20.
Please, my lord.
that has been taken, but income, my lords,
Then in that there won't be any change. As it
Please.
is, it would come to 3 lakh
please, me.
36,000. Then loss of amenities.
Loss of amenities, my lords, is on the
Another
lower.
10,000.
Please, ma'am.
Lords, since the disability is more than 20%,
That's
lords,
what,
may
that's
may I
what court
request
is-
a future prospect should be added to the future prospect should be added, and lords calculated the income for the future loss of earning capacity, my lords.
What do you say? There is shortening of leg.
My lordship, tribunal has been correctly considered, my lordship. Lordship, maybe there is no future, about 20% future.
Because shortening of a leg, how much?
2 centimeters.
2 centimeters.
Centimeters will have an impact.
And in
So-
paragraph number 29, my lords,
No, 1 minute. So 10,000. What is the future prospects?
Yes,
It got 40%.
please,
aged about 40 years, my lordship.
40.
Maybe 25%, up to 40. Is mentioned as 40 years.
$2,500. It comes to 12,500 into 12 into
16.
what is the multiplier?
Lords, multiplier will be 16 or 15 will be 41 years. 15 will be the multiplier. 15 or 14.
40 is 15. Into 15.
Tribunal consider
40
14.
years. 40 years. So 15 will be the
15.
multiplier.
Well, one submission, ma'am. Regarding my lordship, multiplier tribunal has been considered 14 per.
But it is 15 if he is 40, 40 years. As per the table.
As per table, as per the petitioner was aged about 41 years at the time of the
41
accident.
years.
Please, my lord.
Then 14.
Please, my lord.
Disability is 20%.
20%.
It comes to 4,20,000.
Lords, amenities, my lords, only 30,000 is awarded, my lords.
40,000, another 10,000.
Future medical expenses also. The doctor has deposed, and he has told that he requires 2 more surgeries for removal of implants, which would require 50 to 55,000.
One
But
submission.
tribunal, my lords, has awarded only 30,000.
Regarding future medical bills, ma'am. Date of accident 2014, ma'am. Now they 2025, 11 years, ma'am. They have not produced it.
Same argument in all the cases, insurance
No,
company.
ma'am, they have not produced documents to show that future perspective.
There is a
ma'am.
medical
They-
evidence.
Tribunal has taken consider
If the rods
30,000.
are there, he will keep it as it is without having operation. $6,53,000. Next, what is the next MBC?
Please, my lords, MBC
2458.
paragraph number 35 of the judgment. In this, my lords, he has sustained a fracture bone of PD joint.
1 minute, come to the table. How many are the injuries?
My lords, there are 2 fractures, my lords. Table, my lords, is at paragraph 24,
Yes,
internal
it's
page
2
20.
fractures, 60,000. Medical expenses as it is.
My lords, medical and incidental together, they have.
Medical expenses, how much? That
My
we will
lords,
see.
39,833 are the bills, my lords.
39,000?
833.
Yes. How many days you were in hospital?
2 days, my lords. But I have undergone close reduction and K wiring fixation.
No, but ultimately that, so it's better we remain, a court has given reasonable amount. Let it be
Lords,
like
this
that.
is together with incidental expenses.
No, if you are 2 days in the hospital, you will get 2,000.
But surgery he has undergone that.
You are there in the, what consider is that?
Please.
45,000, let it be.
My lords,
Next, earning?
my lords, he is a driver by profession, my lords. DL has been produced. 6,000 is taken as his income, my lords. Accident is of the year 2014 and 8,500 as per the table could be taken.
According to him, what is his income?
Lords, 9,000 rupees per month plus 2,000 per day bata.
9,000 is income. 2,000?
Bata.
No,
per
no.
day.
14 is accident.
14
It's the
accident.
accident.
So 8,500 into
And
3.
there is an amputation of right ring finger, my lords.
Amputation of?
Right ring finger.
Finger.
Ring finger. And future loss of income, my lords, is not been awarded. There is a
Loss
doctor's
of
evidence.
earning during the, what is loss of earning? What is the disability in that?
My lords, 7% the doctor has deposed, my lords. There is 22% disability to the particular limb and 7.3% to the whole body. That entire
With
ground
regard to
has
this
been.
amputation?
There is an amputation, my lords.
No, for that is a disability.
Please, my lords. Not only that, my lords, there are fractures and he has undergone operation and there are disabilities, my lords, otherwise also.
What are that? Let's see the evidence.
Please.
Nothing appears to be so severe. Come to that. In this regard, he has examined 42. 42.
In this regard, he has examined PW5 Dr. Manoj Kumar, orthopedic surgeon, Panacea Hospital, Bangalore. The evidence of PW5 is that he personally treated the petitioner for fractured proximal phalanx, right ring finger, and that the petitioner was treated with close reduction internal fixation with 1.8 mm K wiring and clavicle plate and screws under general anesthesia on 8/5/2014 and discharged on 9/5/2014. In his evidence, PW5 has given a detailed description of the examination conducted by him on the petitioner with regard to assessment of permanent physical disability of upper limb, mobility component, assessment of coordinated activities, and after adding additional points, he has assessed the total body permanent disability at 22% to right upper limb and 7.3% to the whole body.
Instead of taking that amount, this lump sum compensation will increase by another 25,000. Loss of amenities. Two lakh 5,500. from 1,12,000. I'll dictate in the chamber.
The rate of interest, my lord,
Amenities.
enhancement amount maybe 6%, my lord.
Enhanced amount
Please, my
6%.
lord.
Amenities our, and amenities is not award, huh? Only on.
Amenities
fourth.
also awarded,
Please, highly,
partly allowed.
much obliged.
Chamber, yes. And all these matters, remaining matters. These all should come on Tuesday. Only this 18 matters, 17, this 17, these 30, 31, 32, give some other date. But till this 15 matters, till 29, they should come on Tuesday in this number 1. This number 1. And let them not add any matters after 18. If they are date given matters, then only let them add. Otherwise, no 18 matters. And priority should be only to 12, 13, 14, 15. Not even 16, 17. Yes.
I'm gonna make submission of this to serial number 15, my lord, that passed it over. If my lord is sick, may have it in the second week of April. If
Yes,
possible.
yes. Give him the date.
I'm grateful, much obliged.
Number 18.
I apologize for the confusion.
Yes.
Number 18 passed over.
Which one is
This is list number 3.
Number 3.
Myself and Homaish.
Oh, my, it's Raju. It is in.
I'm here, my lord.
13 matters
It
only.
is in dismissal.
What happened?
That is
Morning, sure.
In morning, there was some internet problem in my side. I could not appear.
Let these two be also on the first list on Tuesday. Oh, no, let it be there. All these matters will come on the first list on Tuesday.
Please.
And ask them to add to the final hearing all 12, 13, 14. Not to add any later matters. But then only they'll come. Otherwise, not to add. Yes. Keep promotions. Community responsibility.